maybe postpone stand copy of the record special case number lordship 39 2020
900 and how many days?
34 days.
Lucky
Third,
Burman.
Mr. L. R.
I
Majumdar,
can see.
Learned Counsel for the
My lord, that is his item number 3. You are?
3.
My lord, here is it is shown as Lucky Burman. Your item number? Pass in another code.
What happened?
Confusing.
What conflict?
My lord, in the cause list, it is shown Lucky Burman. He is appearing for Lucky Burman. But
The
Oh,
what
sorry,
is-
lordship. I'm very sorry.
he parts in another code.
I'm very sorry.
Okay.
But seniorism will be code number 2. Maternity,
No, let us call for the case.
CD, my lord.
Case
CD, my
there.
lord.
What is your name?
From Kamar Bokhisto, my lord.
What is your name?
D. Goswami.
Third, Mr. D. Goswami, Learned Counsel for the petition. Not to
Yeah,
petitioner, and additional purpose.
Mm.
Let the case diary be called for as perusal of the same would be necessary
My
for
lord.
consideration of the instant payment.
No,
Let this case be fixed on
28 mile.
28/11.
My
Item number
Okay.
4. May it please your lordship, I'm very sorry for the inconvenience, my lord. I made a mention, my lord, of item number 33, my lord. There was an interim order
In 33 interim order.
and deeply outlet. 4.
May I please, your lordship? 439 application, your lordship. The allegation is in connection with Azara PS case number 223/23, madam. Under section 325, 306 and 34. Now, there are two petitioners here. Na? One is behind the bar since 26/10/23 and another one is 20 from 27/10/23. CD may be called for along with the PM report.
Third, Mr. K. Thakur, Learned Counsel for the petition. Also, our Mr. B. Sharma, Learned Petitioner.
Multiply.
Let the case diary
Okay.
be called for as perusal of the same would be necessary for consideration of the instant payment application. Let this matter be listed again.
My lord, from Azara, my lord. 29th, my lord.
29/11 for case.
Can you please?
Item number 5.
For 39 believed it. It is on 2/11/2023. Allegation 366. Victim already has recovered matter. For Mulur PS for that may be given.
Third, Mr.
Okay.
A.K. Azad, Learned Counsel for the petition. Also, B. Sharma, Learned Petitioner. Perusal of the case diary for consideration of instant payment application. It's called for fixing
28, my lord.
28/11.
Maybe
for
earlier,
case.
26, 24.
No,
Komulpur, my lord. Amrudhi.
today is JF vacation. 2 days.
Komulpur, my lord.
No, it is on the prosecution.
My lord,
My lord.
we will have to take steps for calling city, my
Let
lord.
it be on
28/11.
Item number 6.
May please. 439 application. 42 days in custody allegation is under section 366 IPC.
Yes, very good.
My lord,
42 days for that may be given.
Third, Mr. T.
from Dibrugarh.
Learned
How will
Counsel
be?
for the petition. Also,
Hmm.
perusal of the case diary for consideration of instant payment application. Hence, call for the case diary fixing
My lord, 30/30, my
30/11 for case.
It's getting hot. I don't want to order it.
For motion, item number
28 no.
29, my lord. 29.
29.
Now, Lord.
My lord, my first prayer is this. Respondent number 1, phase 3, That is not necessary party, perhaps observing a similar petition. So respondent number one may be kindly deleted, thereafter I am submitting next.
One is
Not CR case, it is pending before learned Judicial Magistrate Court at Tirang, so that is not there case, here. And pending in, so respondent number one name may kindly be deleted.
Okay.
Now my submission is this, my lord. We have filed this petition for quashing matter.
response number one is deleted. No? Yes, it may be.
There is
Lordship?
there is a process for striking out of. If you want, otherwise you want this court to give order.
My lord, lordship kindly see page 22, my lord. Here, legal heirs of Shamsul Haq, kindly see page 22, legal heirs Shamsul Haq, Akabbar Ali. This Akabbar Ali is the petitioner number one in this case. And the rest of the legal heirs of Shamsul Haq are also the accused in this case, including all domain men. So civil case is pending, and here in that civil case, my lord, the present respondent, that is my lord Nurjahan Bibi. Now kindly see page 21. Defendant number one, Nurjahan Bibi. So she is the, my lord, complainant in this case. And land lordship you kindly see. Where is the land? Kindly have a look to page 31. Page 31, Schedule A. Village Satiborgaon. Second line, Village Satiborgaon. Lordship has seen?
Yes.
Village Satiborgaon. Now lordship may kindly see the CR case which we have prayed for quashing, page 14, man. It is Nurjahan Bibi. So Nurjahan Bibi has filed the case, and accused persons are Akabbar Ali, Abdul Awal, Asghar Ali, etc. Now, what is their age? Lordship may kindly see the age of these persons. Page 12 kindly see, man. Sorry, page 2. Page 2. Akabbar Ali, 51 years. He is a teacher of a government school. Abdul Awal, I am not telling his age because he is young. But Ayesha Bewa is 65 years. Bewa means widow, my lord. Then lordship will see petitioner number 8, Abdul Jabbar, 67 years. Ishkor Ali, 58 years. And Toyib Ali, 58 years. And Shahira Khatun, 48 years. Now, allegation lordship would kindly say, page 17. Page 17 from 2 kindly see. That the complainant has a plot of land in the village Satiborgaon, the same village, same plot of land for which civil suit is pending between the parties. 3. On 22/6/23 at 8 p.m., the above named accused persons illegally trespassed 8 p.m. minor. That is night. Illegally trespassed in the paddy field of the complainant with a criminal conspiracy to do illegal act by plowing the aforesaid plot of land. Now 67 years lady, 68 years old man will go to the land at 8 p.m. for plowing, and that too in respect of title suit. That is, my lord, is it believable? It is totally unbelievable. And when the case is pending between the parties regarding the right title intent. Now, lordship kindly see, we are the joint possessor. Kindly see now for a moment, page 27. page 27. Uh, Para 4, Lordship. The plaintiffs and the defendants are the joint owners of all the scheduled lands as inherited from their father, grandfather, husband, late Nurul Sheikh. Now, the lands are Satiborgao, Lordship, I have already shown. So 31, joint owner. When the parties are joint owners, how there can be illegal trespass? And over and above, the petition number 1 is a teacher, well, government school teacher. And my lord, now kindly see that what is the difference in star witnesses. Kindly have a look page 36, my lord. 36. She is the complainant. She says that I have lost the instant case. I have filed the case against Akabur Ali, Aisha Khatun, Sahara Khatun, Atwar, Rahman, Asghar Ali, Abdul Awal, Ishkor Ali, Jahirul Islam, Abdul Jabbar, Abdul Hai, and Tayyub Ali. On 22/6/2023, in the night at around 8 p.m., I got to know that the accused persons were plowing in my paddy field. Now, Lordships, kindly see page 38. What are witnesses there? PW2 is her husband. So their sayings are more or less same. Now, this is the only independent person what he says. Instant case has been filed by Nurjahan Bibi. The case is filed against Akbar Ali so-and-so name in the month of June 2023. Month of June, month 2023, there is no date. Abdul Jabbar, Abdul Hai, and Tayyub Ali in the month of around 8 to 8:30 a.m. She says 8 p.m. and he says, her witness say 8:30 p.m. Now, Lordship would kindly see, although this is not the so long time for argument, the Honorable Supreme Court, in case of Nain Singh and another, it was said that several inconsistencies regarding the timings of occurrence, deep-rooted enmity between the parties. So there is a civil suit, and all women are going to plow their lands, which is under joint possession of the parties, and that to 8 p.m. Nowadays, teachers normally do not plow.
What is the next date fixed?
Next date fixed, my lord, that Lordship may kindly see. Next date was 1/11/23, but on that day, parties did not appear because they did not got summoned at appropriate time. The immediate next, I am giving after 5 minutes, calling the person. So my prayer is this, and after 5 minutes, I will give that.
So let us take it up.
My lord.
After 5 minutes, we will take it up because otherwise we are issuing notice. We may issue notice to the.
Notice, but till then,
Therefore, I was asking what is the next date fixed.
let me kindly take 5 minutes time. I am going outside and calling client and then
Call it up.
after 5 minutes.
May I please ask a petition for questioning the impugned order dated 15/9 passed by SDJ, Honorable SDGM Dibrugarh. If kindly fresh report may be called.
What is the order? Where is the impugned order?
Page number 28. Annexer G.
Your Jimma petition was rejected. Heard, Miss
R. Shaheen.
Heard, Miss R. Shaheen, learned counsel for the petitioner. Also heard,
I, Borthakur, for Excise Department.
Mr. I. Borthakur, appearing for learned counsel for the excise department. This application under section 482 of the Code of Criminal Procedure, 1973, read with section 397/401 of CRPC of the said code has been filed by the petitioner Devraj Sahib, impugning the order dated 15/9/2023 passed by learned subdivisional judicial magistrate Sadar, within brackets Sadar, Dibrugarh, whereby the prayer for interim custody of seized vehicle bearing registration number RJ 14 GG 0801 was rejected. You also sought remove the seized consignment of beer. Seized vehicle or people, as well as consignment of 1200 case as well as of the seized consignment of Turbok strong beer was rejected. Stop. Issue notice to the respondent since Mr. R.
I, Borthakur.
Mr. I. Borthakur, learned counsel for the excise department, appears for all the respondents.
Only Excise Department, but for this.
All are from excise department.
Yes, all the response.
All the respondents, no formal notices need to be issued to the respondent. What is the case number in connection with which? You will produce the case diary.
Yes. I'll
Perusal of the case diary is necessary for consideration of the instant criminal petition. Let the case diary of the relevant case be called for, along with a report from the investigating officer whether continued retention of the seized vehicle is necessary for fair investigation of the case. Let this matter be listed when you can produce the case.
Lordship, I have received a communication that they are giving an application for confiscation. So by the end of today, I will get a copy of that
No,
application.
you take 10 days time.
Yes.
Let this case be listed again on. Give it 10. 11, 12 for report.
Can it be on 7th?
7th December.
Yes, my lord, I have got information. 18/11, that is day after tomorrow. So notice may kindly to elsewhere may be called for. And a stay may kindly be granted. It's a fit case to be quashed. Litigation not to harass the person. It should be objective, not subjective.
No, but the allegations are of under other provisions of
447.
294/506.
No, Lordship, kindly you will hear the parties. For the time being, I hope that I could satisfy Lordship prima facie. There is the deep-rooted enmity between the parties. And when civil suit is pending, Lordship is aware the decision of civil court is binding upon criminal court. But criminal court's decision is not binding upon civil court.
No,
But-
no, when there is a specific allegation of commission of an offense.
Especially
No.
absurd and vague.
Therefore, we have to hear
Yes,
the
sir,
other side before giving any interim relief.
that maybe examined by your lord.
Heard Mr. M.U. Ahmed, Learned Counsel for the petition. Petitioners also heard Mr. B. Sharma.
Mine.
No, you
No,
are not
they are
required.
not party.
In the petition, there is a-
Learned Counsel for the petitioner. This petitioners, this application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner for quashing of the CR case number 16/2023 under section 323/394/34 of the Indian Penal Code, which is pending before the Court of Learned Judicial Magistrate First Class, Dibrugarh. The Learned Counsel for the petitioner submits that though the petitioner has made state of Assam as respondent number 1, however, as the petitioners have approached this court for quashing of a complaint case where the state is not a party. Therefore, name of the respondent number 1 may be strike out from the present criminal petition. If prayer is allowed, registry shall strike out the name of the respondent number 1 from the present criminal petition. Stop. Learned Counsel for the petitioner has submitted that the respondent number 2, the respondent Noor Jahan Bibi, has lodged a criminal complaint case number 6, which has been registered as CR case number 16/2023 against 11 numbers of accused persons who are the petitioners in this criminal petition. It is alleging that the present petitioners have had trespassed into the land of the respondent, which is situated at village Sati Borgaon under Sidli Revenue Circle in district of Sirat, and have assaulted the respondent and had uttered obscene word and pushed the respondent, as a result of which the respondent fell to the ground. Learned Counsel for the petitioner have submitted that in respect of the said plot of land, there is a pending civil suit between the parties, which is registered as title suit number
37/22
and is pending in the court of Learned
civil
Civil
judge.
Judge Sirat. Title suit number 37. Civil Judge Sirat. And counsel for the petitioner has also submitted that learned trial court ought not to have taken cognizance of the offense alleged in the complaint as there is apparent discrepancies between the testimony of the complainant, which was recorded under section 200, as well as the witnesses as regards the time of the offense, alleged offense. It is also submitted that the petitioners, most of the petitioners,
Joint position.
that the petitioners as and the respondent are
In the joint position of the
in the
alleged.
joint possession of the disputed land. And the present complaint has been, and the complaint has been filed by the respondent side. Respondent only to harass the present petitioner. So issue notice to the respondent. The petitioner shall take step for issuance of notice on the respondent by registered post with ID within 2 days from the date of this order, returnable after 3 weeks. However, considering the facts and circumstances of this case, the further proceeding of CR case number 16 slash, no, CR case number
16/2023
16/2023.
pending in the court of London Jail
pending in
first class
the court
Kirang at Kajalgaon.
of first class Hiran at Kajalgaon shall be kept in abeyance till the return of the date. We will hear till the
But-
return of the date.
but-
Let this case be listed again after 3. Yes,
MU Mahmood, not
what I have said.
Lordship Saidi
Okay,
Ahmed.
sorry,
That's
sorry.
no problem. That is common. All right.
Item number 9.
May I please your lordship? Hello, the court party application method and petitioner is the accused number 2, the murder of the accused number 1 method, occurred at page 8 minutes.
Petitioner is mother.
Murder of the accused number 1 method and the mother-in-law of the victim method. And accused number 3 is the auntie. It is,
What is the allegation?
my lord, allegation, my lord, at page 8 minute affair. She left 2 sons, my lord, 2 minors. They are staying with me. I am taking care of these 2 minors.
How he died?
My lord, I have instated, my lord, even trial court, my lord, this plea was taken by the accused number 1, my lord. That on that some quarrel taken place between the husband and wife, and she consumed, my lord, some poisonous medicine, my lord. Consumed medicines, my lord. After this incident occurred, my lord. Earlier, my lord, accused number 2 and 1 approached, my lord. Granted bail, my lord, accused number 3, and accused number 4, trial court bill, accused number 3 was also granted bail, my lord. At page 14, my lord, I also moved along with the accused number 3, my lord, but my case was not considered, my lord, and accused was granted for 30th application. Yes, my lord.
And what happened to accused number 1?
Accused number 1, he was arrested, and this honorable court granted absolute bail.
He's on bed.
Yes, yes.
Okay.
And
My
I am
lord-
taking care of 2 minor sons, my lord, right now.
My lord, here, my lord, petitioner number 1, my lord.
One
FIR
petitioner
petition
is
number 2, my
order.
lord. It was rejected by the court below, my lord. After going through the case there, my lord.
Where is
Page
the
15, my lord. Page 15, my lord. Page 15, my lord. May I read, my lord?
Yeah.
Perusal of the CD reveals that sufficient incriminating materials has been found against the accused Anjana Rani Das, present petitioner. However, custodial detention of the accused petitioner Sandhu Sikdar is not required for the purpose of investigation of the case. However, the investigation was thereafter, my lord. Considering submission made by the Lion so considering the material CD, I am opinion that custodial detention of the accused petitioner Sandhu Sarkar is not required for the purpose of investigation of the case. Moreover, the investigation case is progressively. Hence, PR's bail prayer of the accused petitioner Sandhu Sikdar is allowed. And the PR's bail petition for the accused petitioner Anjana Rani Das is rejected as sufficient incriminating materials found against her. Let's call for CD at this.
I'm taking care of two minor sons. Still
No,
arrival.
but and what happened to main accused has been released on bail.
Yes, that is page
My lord.
17, my lord.
Whereas after getting in the custody, my lord, I have no information whether his 90 days completed or not, my lord.
Page
After
17,
the
page 17, lord. I got it.
17.
17. Okay.
Let her appear.
No.
Mr.
PK Dekar.
P.K. Dekar, counsel for the petitioner, also heard Mr. P. Sharma and an additional prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Srimati Anjana Rani Das, who is apprehending her arrest in connection with Silchar PS case number 1432/23 under section 498A/302 of the Indian Penal Code. The gist of accusation in this case is that on 2/8/2023, one Rajat Kanti Dev had lodged an FIR before the in charge of Rangir Khari, the police outpost, Silchar, under which police station?
My lord, Silchar PH.
Under Silchar police station, inter alia, alleging that the daughter of the first informant, who was married to the accused number 1 named in the FIR, was brutally tortured by the accused persons named in the FIR, including the present petitioner, and later on she was killed by the accused person. Stop. Learned counsel for the petitioner has submitted that the present petitioner is the mother-in-law of the deceased, and there was a matrimonial dispute between the husband and wife, after which the deceased had consumed poison, as a result of which he died. It is also submitted by learned counsel for the petitioner that in the meanwhile, the petitioner number 1, who is the son, in the meanwhile, the accused number 1, Debojit Das, who is the son of the present petitioner, was arrested and later on granted bail by this court. In BA case number 3590/2023. It is also submitted that who is Chandu Sikdar?
Auntie, my lord,
The accused number 3 named in the FIR has also been granted bail by the
additional session judge,
additional session judge,
FTC,
FTC
Kasar
Silchar,
Silchar.
Kasar Silchar. It is further submitted by learned counsel for the petitioner that the
Two minor sons I am
the
taking.
petitioner is looking after two minor son of the deceased.
Yes, my lord.
And he is ready to cooperate with the investigation, in the investigation. On the other hand, learned additional public prosecutor has submitted that the bail prayer for the present petitioner was rejected by the Court of Learned Session Judge after perusal of the case diary, finding sufficient incriminating materials against the present petitioner. And on that ground, he opposes the prayer for bail of the present petitioner. Stop. It is also submitted by learned additional public prosecutor that considering the nature of allegations made in the FIR, perusal of the case diary would be granted. Stop. Call for the case diary. Fixing.
My lord, and then Silchar, my lord. Seventh, my lord.
Fixing 7/12
12.
for case diary. However, in the meanwhile, as the present petitioner is a
Anjana Rani Das.
woman of 58 years of age, and also considering the fact that other two named accused in the FIR are already on bail, she is hereby directed to appear before the investigating officer of Silchar PS case number 1432/23 and cooperate in investigation. Stop. If she does so within the stipulated period of time, the petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of arresting authority, with a condition that she shall cooperate in the investigation. Let this case be listed again on 7th of December.
Deep.
Item number 10.
I'm on behalf of JC Border. Matter may be taken up at 2 lot. He is on Lakes, court number 17.
My lord, here is the charge-sheeted case, my lord.
Charge-sheeted case.
Charge-sheeted case, my lord.
Let us
Can you
call
call for scan copy of the case record, my lord, along with CD, my lord.
charge-sheeted case. What is your
I have no subdivision because I am on behalf of membership. He telephonically informed me to fix the matter at 2 lot.
Okay, let us take it up.
At 2 lot.
Item number 11.
Meet the order. 238 applications, my lord. Offense is 302, page 11. Already petitioners were not named in the FIR. And my lord, they are not involved in these incidents, my lord. May I read the FIR? The particular page 13, my lord.
Yeah. Then why are you apprehending your arrest?
My lord, what happened, my lord? After occurring this incident, my lord, the police visited the village and they pick up one after another local boys of that village, my lord. And till now, my lord, there are 6 boys were picked up and they were sent to jail. Subsequently, they all are allowed to bail. And my apprehension is that since I belong to that village, my lord, I may be arrested. Police searching me. But each and every boys were picking up, my lord.
Then we'll peruse the case file.
Maybe, my lord. Occasionally may be called for, my lord. Meanwhile, my lord, my eye protection may be granted to me, my lord. Otherwise,
No, we don't know what material is there.
yes, indeed, my lord. If any material against me in the CD, my lord, the interim may be cancelled, my lord. Nothing else. My lord, till the interim CD, my lord, I may be protected. Since our name was not in the FIR, my lord, my humble submission at this stage, my lord, for interim protection. CD may be called for, my lord. If any materials in CD against us, my lord, the court may be at liberty to cancel my entry. Otherwise, I will be harassed by the police. It may be called for.
Where is your statement that police is searching it in the petition?
Paragraph 6, my lord. Page 5.
Heard Mr.
DK.
D.K. Das, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Prafullo Pator and Ananto Pator, who are apprehending their arrest in connection with Jagirot PS case number 181/23 under section 302/34 of the Indian Penal Code. The gist of accusation in this case is that on 1/6/2023, one Vikas Bordole lodged an FIR before the officer in charge of Nelly Police Station, inter alia, alleging that on 29/5/23, when the family members of the first informant were sleeping after taking dinner, the wife of the first informant woke up after hearing hue and cry outside the house. And when she came outside, she saw two unknown miscreants had committed murder of the father of the first informant by throwing him into the well. Learned counsel for the petitioner has submitted that petitioners are no way involved in the offense alleged in the FIR. It is further submitted that they are also not named in the FIR. However, the police is searching them, and police have also indiscriminately arrested some of the other villagers of the village in which the petitioners reside, and therefore they are apprehending that they may also be arrested in connection with this case. It is also submitted that the petitioners are otherwise ready to cooperate in the investigation. On the other hand, Mr. B.B. Gogoi, learned additional public prosecutor, submits that considering the nature of allegations leveled in the FIR, perusal of the case diary would be necessary. Hence call for the case diary fixing. 8/12 for the case diary. However, considering the fact that at this stage, from the materials available on record, nothing appears against the present petitioners, nothing incriminating appears against the present petitioner, and also considering the fact that they are willing to cooperate in the investigation, the present petitioners, the above named petitioners are hereby directed to appear before the officer in charge of, before the investigating officer of Jagirot PS case number 181/23 within a period of 10 days from the date of this order. And if they do so within the stipulated period of time, in the event of their arrest in connection with Jaggi Road PS case number 181/23, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of title, subject to the satisfaction of the arresting authority with following condition. They shall cooperate in the investigation. They shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer. Let this case be listed again on 8th of December.
Item number 12,
May I please, your lordship? My lord, it's a 430 application, my lord. And here in this plot, FIR page 10, my lord. And though, my lord, named 3 accused persons, my lord, and there are more than 13 persons also, my lord, allegations, my lord. And basic allegations against the accused number 1, my lord, at page 10. And both the accused number 1 is my brother-in-law, accused number 2 is my own brother, and I am the accused number 3, my lord. Rajuddin, alias Abdul Manaf Loskar. And both the accused number 1 and 2 granted bail by the London Trial Court below, my lord. And with accused number 2 and 3, by myself, I approve making application. My brother bail application considered, but my case was rejected. That some incriminate materials found against me, my lord. Also, kindly have a look. Well, FIR at page 10.
Yes,
Yes, my lord. Kamrul Islam Loskar is the accused number 1, my lord. 2 is the Abdul Hanan Loskar. I am my lord Rajuddin Loskar. This is Abdul Manaf, my lord. And in the entire FIR, lordship, you see, my lord, basic allegation against the accused number 1, my lord. He hit his wife's head, my lord, accused number 1, with a down, and she fell down and other accused person. And thereafter, my lord, they said that they snatched away one gold chain, my lord, like this, my lord. More than 12 and 13 unknown persons implicated in this case, my lord. And we have been named 3 persons here, my lord. And page 20, my lord, the prime accused number 1, my lord. This regular bail case moved to trial court, my lord, and according to page 20 was granted bail. That is on 26 September 23, my lord. Kamrul Haq Loskar. And thereafter, my lord.
where is the bail order of the main accused?
Yes, page 20, 20. 20, my lord. Kamrul Haq Loskar, my lord.
This is regular bill.
Regular bail. Thereafter, my lord, my brother accused number 2 is anticipatory bail granted. Page 21, that order. I also moved with my brother bail application along with my brother, my lord. My case was not considered.
Otherwise, in the FIR, main allegation are against accused number 1.
But
One minute.
his bail petition rejected by the court below. Might be some material against him, my lord, in the diary.
Page 21 is the order, my lord. Abdul Hanan Loskar, this is accused number 2, and Abdul Manaf Loskar, this is present petitioner, my lord. Page 21. Accused number 2, bail case considered, my lord. My case was rejected.
Mr.
PK.
P.K. Dekat and counted for the petition. Also heard Mr. P.P. and the additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abdul Manaf Laskar alias Raju Uddin Laskar, who is apprehending his arrest in connection with Silchar PS case number 1687/23 under section 147/148/448/354/326/379 of the Indian Penal Code. The accusation in this case is that on 3/9/2023, one Abdul Jalil Borbhuiyan lodged an FIR before the in charge of in charge of Arunachal outpost.
My lord, the Silchar PS case,
Now, which-
FIR loss
or FR loss, yes, my lord.
the Arunachal outpost
Yes, ma'am.
under Silchar police station. Inter alia alleging that
It would take
on
it.
1/9/2023, when the first informant was sleeping in his home, in his house, along with his family members
7, 8.
at about 1 a.m. The accused persons named in the FIR, including the present petitioner, trespassed, came to the veranda of the house of the first informant and started calling out name of the first informant. And when he went outside, he was assaulted by the accused person. What was the injury?
Allegation, the accused number 1, my lord,
No, injury report
Oh.
there. আছে নাকি?
right,
In which he
ইয়াতে mention ও করা
suffered sustained
report আছে।
injuries on his hand and other parts of the body. It is also alleged that the accused number 1, namely Kamrul Islam Laskar, also assaulted the wife of the first informant and causing injuries on her person. Learned counsel for the petitioner has submitted that the accused number 1 named in the FIR, namely Kamrul Islam Laskar, was arrested and later on was granted bail by the Court of London. Additional Sessions Judge Kachar Silchar. It is also submitted by Learned Counsel for
my lord, accused number 1 by Chief Judicial Magistrate Kasar and accused number 2 by Additional Session.
Chief Judicial Magistrate Kachar Silchar. It is also submitted by Learned Learned Counsel for the petitioner that in the meanwhile, the accused number 3 named in the FIR, Raju Uddin Laskar, has also been allowed to go on anticipatory bail by
No, my lord. My brother, Abdul Hannan Laskar, accused number 2 was allowed. Abdul Hannan Laskar.
you are,
I am Abdul Mannak Laskar, this is Raju.
oh, you are Raju Laskar,
Yes.
sorry. Abdul Hannan Laskar was allowed to go on bail, anticipatory bail by Learned Additional
Session Judge
Session
FTC, Kasar
FTC
Silchar.
Kachar Silchar. Learned counsel for the petitioner has submitted that there is no specific allegation leveled against the present petitioner in the FIR and he is ready to cooperate in the investigation. On the other hand, Learned additional public prosecutor has submitted that the prayer for anticipatory bail of the present petitioner was rejected by the Court of Learned Additional Session Judge FTC Kachar Silchar after perusal of the case diary, and therefore perusal of the case diary would be necessary for consideration of anticipatory bail. So hence call for the case diary fixing. Give a date.
Yes, my lord, 6/12,
Six,
7.
7/12 for KZ. However, in the meanwhile, as other two named accused persons in the FIR are already on bail and the petitioner is willing to cooperate in the investigation, he is hereby the petitioner is hereby direct. Petitioner Abdul Manaf Laskar alias Rajuddin Laskar is hereby directed to appear before the investigating officer of Silchar PS case number 1687.
My lord, 1678, my lord, the typical error, my lord. I may be 1678. Sure, 1678. That's a typical error. It is correct in the FIR, my lord. And only in the matter of importantly, my lord, is it 1687, 1678, my lord.
Then you have to ensure that once it is placed before the court, all your errors are rectified.
My lord, all the 1678. Just here, my lord, typical, my lord.
This may be a reason for rejection of.
No, my lord, it is 1678, my lord. Kindly have a look, my lord. All in 1678, but typical error.
Silchar PS case number 1678/2023 and cooperate in investigation within 10 days from the date of this order.
Yep.
Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Silchar PS case number
1678.
1678/2023, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. He shall cooperate in the investigation and shall appear before the investigating officer as and when so required for the sake of fair investigation. Number 2, he shall not directly or indirectly make any inducement, threat or promise to any person who is acquainted with the fact of the case so as to dissuade such person from disclosing such facts before the investigating. Stop. Let this case be listed again on 7/12.
My lord, can I rectify, my lord? This,
You file in the meanwhile, learned counsel for the petitioner has submitted that there is a typographical error in the cause title of this bail application
and prayer.
in as well as in you have to file a
Yes,
petition and he may be allowed to rectify the said error.
Yes.
The prayer is allowed. The petitioner shall take steps before for rectifying the said error before the next date fixed.
Item number 13.
May I please, the Lord. For 30th bill application, my lord, page 11 is a Bhadakula Kotote FIR. Case has been registered under section 366. The petitioner is not a named accused, my lord.
366.
366. Lordship, may kindly see the page 11 FIR, my lord. Bhadakula Koma FIR.
The girl is yet to be traced out.
She has voluntarily appeared before the IO. Her statement was recorded judicially on Article 164. And after recording of the statement judicially, the London magistrate has allowed the victim to go with her parent.
And who are you?
I am Ricky Putti, but I am the
How you are?
yes, my lord. I am the distant related of the name accused Nokul Bhumi. So after the alias apparent, the name accused Nokul Bhumi has telephoned me on my mobile number. That's the case. Police have tracked my number and trying to apprehend me in connection with this case. Lordship, may kindly see the page.
Victim already recovered, 164 recorded.
It is a law affair.
Not with you.
Not me. I'm not related to the name Nikit Nukul Bhumi. Correct.
Heard Mr.
Yes, Google, my lord.
S. Gogoi, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioner Ricky Purti, who is apprehending his arrest in connection with Lalu PS case number 204/23 under section 366 of the Indian Penal Code. The gist of accusation in this case is that
Next to many.
on 26/10/2023, one Shri Chandra Mali had lodged an FIR before the officer in charge of Harmati Police Outpost, Police Outpost under Laluk Police Station, inter alia, alleging that on 25/10/2023 at about 6:30 p.m. the daughter of the first informant went missing, and later on the first informant came to know through reliable sources that one Nakul Bhumich has taken away his daughter. Stop. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR. However, he is the distant relative of the named accused, namely Nakul Bhumich, and he got a phone. Why police is searching you?
The name Nikit said telephone me after the early department.
And the named accused had called him over mobile phone after the alleged offense, and therefore police is searching the present petitioner. It is further submitted by learned counsel for the petitioner that in the meanwhile the victim girl has been recovered, and her statement under section 164 PRPC has been recorded. It is also submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor submits that considering the nature of allegations leveled against the present petition, level in the FIR, perusal of the case diary would be necessary, hence call for the case diary. However, considering the submissions made by learned counsel for the petitioner Ricky Purti is hereby directed to appear before the investigating officer of Laluk PS case number 204/23 within 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Laluk PS case number 204/23, he shall be allowed to go on interim bail of 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. He shall cooperate in the investigation and shall appear before the investigating officer as and when so required by the investigating officer. He shall not directly or indirectly make any use or promise to any person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts to the investigating officer. Let this case be again listed
11-12.
on 11/12 for case type.
Deeply obliged.
Item number 14.
কৰিব লাগে।
His lordship, the same matter, my lord, he is the named accused in this case, Nukul Bhumi. The FIR is in page 10 in the vernacular form, my lord,
No, named accused, we have to peruse the case. Right?
my lord. But we are ready to cooperate in this thing and.
Heard Mr. S. Gogoi, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. Stop. Considering the nature of allegation leveled against the present petitioner, the FIR, perusal of the case diary would be necessary for consideration of the instant bail application, anticipatory bail application. Hence, call for the case diary. Fixing date is given already.
December
12,
11/12.
11/12 for case.
My lord, obliged.
Item number 15.
May it please the Lord. Lordship will find FIR at page 13, Lord. May I read it, Lordship? মই সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 16-10-2023 তাৰিখে ৰাতিপুৱা মই গৰু এৰাল দিব যাওঁতে পদকীয়া পূৰ্ণকান্ত মুদাকে মোৰ হাতত ধৰি মোক মুখখন হাতেৰে ঢাকি বলপূৰ্বকভাৱে লৈ এখন বাঁহবাৰী লৈ যায় আৰু বাঁহবাৰীত ৰাখি মোক
Case diary would be.
Lordship will find for a moment, Lordship will peruse in the page 15, Lordship. For a moment. In the lower part, Lordship, admittedly there is a love affair between these two persons, Lordship, and they are having their own family, Lordship. And to that extent, Lordship.
Page number 15.
Page 15, 1-5. I am taking Lordship to the vernacular version of the.
What is this?
This is a Lordship meeting conducted for the relationship between these persons, the informant and the accused, on Lordship 21/6/2023. And here Lordship will find the statements of the both the parties, husband and wife, statements, Lordship, where it is admitted that there is a love affair between them. And as per this agreement, Lordship, they have stated that they would have not any relationship, Lordship, further. And this FIR has been lost, Lordship, because the informant used to call the husband, Lordship, the accused. And Lordship will find in my paragraph, I have categorically stated, Lordship, the husband of the informant assaulted the petitioner, Lordship, on 16. And to save his own skin, Lordship, this FIR has been lost, Lordship. For a Lordship will peruse the statements given by the parties in the meeting held in presence of the village admin and Mohila committee, Lordship, and in presence of other persons, the TMK and those persons, Lordship. The signatories were there, Lordship. Lordship will find the signatures at page 16-17, Lordship, and statements at page 18 onwards, Lordship. Lordship, for a moment, Lordship may peruse that statement, Lordship, which reveals there is a love affair, and earlier there was a love affair, Lordship, between the parties.
No, regarding the alleged incident.
Lordship, the alleged incident is completely baseless, Lordship. Lordship, for a moment, Lordship will, if Lordship peruse the FIR for a moment, Lordship, the contents of the FIR itself reveals, Lordship. The next line, Lordship, Gotei rati muk thakibo koi. And she stayed there as per the allegation, but this is completely false, Lordship. The schedule reveal everything, Lordship. At this stage, if Lordship pleases, Lordship, I will cooperate with the investigating agency, Lordship, and I will record my statements, Lordship, because that will be.
No, what is this agreement resolution?
Resolution is, Lordship, the earlier the informant and the accused,
Before the incident.
Prior to the incident.
Prior to the
incident occurred in the month of October, and they
this
had
resolution is of June.
June.
much prior, Lordship, and
So
they
this
had the
is not
irrigation.
relevant.
Sorry, Lordship.
This is not relevant because prior to the incident, there may be a resolution, but your allegation against you is in relation to an incident which occurred in the month of
October.
October.
For a moment, Lordship may again peruse the FIR, Lordship. FIR itself, if the contents of the FIR is read as a whole, Lordship, FIR itself reveals that this incident cannot happen only, Lordship.
Why?
Because, Lordship, it is a village, and in that village, Lordship, if someone is taken to in the morning half and she came back in the next day, is it possible, Lordship, that her parents her families has not searched for her, Lordship? And in my paragraph, Lordship, I have categorically stated, Lordship, actually the main actual story of the case is, Lordship, that on 16, the husband of the informant assaulted with the accused petitioner, Lordship. And I have a minor child
No.
to look after, Lordship. At this stage, my interim protection will be granted. I will appear for the IO and I will record my statement, Lordship. Because, Lordship, otherwise my equity will be defeated, Lordship, because I have to look after my age-old parents. And, Lordship, the allegations are completely false. CD will reveal everything, Lordship.
So let us peruse this.
Lordship, till then I will protect so that I can appear and record my statement, Lordship. Because if I won't be able to record my statement, Lordship, then I won't be able to bring on record the other relevant documents, Lordship. And
No, here the question of document is not there.
yes, and Lordship, the assault which was done to me, Lordship, that could also been could not been established, Lordship, because if I could not appear for the IO, Lordship. Because on the next day when the FIR was lost, I am, Lordship, apprehending arrest, Lordship.
When can you bring the case ready?
Gogamukh, my lord, shortest date, my lord, 6/12.
Before that,
Before
in
that,
this
then 4/12.
in this month, last part of it.
Yes, 30.
Because she has made grave allegations against you.
Yes.
If, my lord, she has filed false case, my lord, then one case should be registered against that informant. So why she drag
No.
that man, my lord?
No, no.
If he is innocent.
Without perusing the case.
That's why, my lord, the diary is required, my
And
lord.
as per my
And this
information,
type of, my lord, compromise or, my lord, press meeting, my lord, it will not do.
And, as
76 case.
as per my information, Lordship, now, Lordship, the informant, Lordship, has intimated the wife of the petitioner that she is willing to withdraw the case, but that is not possible in the eye of law, Lordship, because offenses are CF. Now she is willing to do that, but that is not possible at this stage, because already case has been registered.
Heard Mr.
S.N. Krishnathrep.
S.N. Krishnathrep, learned counsel for the petitioner. Also heard Mr. B.P. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Purnakanto Medok,
Yes.
who is apprehending his arrest in connection with Gogamukh PS case number 105-23. So,
Lordship, for a moment, Lordship, I be allowed to correct one. Section 354 has been inadvertently recorded in my post title, Lordship.
কেনেকে কৰিব পাৰে?
No, no,
That is all right. কেনেকে কৰিব পাৰে?
learned
Hatere
counsel
নোৱাৰা।
for the petitioner has
আজিকালি
also submitted
online
that
filing হৈ যায় না।
there is an inadvertent typographical mistake in the cause title of the bail application and seeks leave of this court to correct the said typographical mistake. If prayer is allowed, the petitioner shall take necessary steps for correcting the said typographical mistake. Considering the allegations leveled against the present petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing. 28, fixing 28/11/40.
For admission, I could.
May I please, Lord? What the petitioner file is Mr. Petition, my lord, for transferring the NI case which is filed at Lakhimpur, my lord, from Lakhimpur to either to Dibrugarh or Horaida, my lord. Negotiable instrument at my lord. There are three page 3, para 5, my lord. I have stated the my lord, the ground, my lord.
Have you filed objection?
Lordship, I have
You have
I have
filed
said this on record, my lord. I have filed on 14/11.
objection is not there on
My practice.
PDF.
May
No.
an extra copy into or let it come out on record. Some other day.
Otherwise, it is ready. After-
Otherwise, ready.
Let the objection be
Sir.
be heard. Mr.
Hey, how are you?
A. Havari, learned counsel for the petitioner, also heard Mr. Mr. G. Soikia, learned counsel for the sole respondent. On perusal of the office note dated 14/11/23, it appears that no objection has yet been filed. No objection is there on record. No objection has yet been filed by the respondent side. However, learned counsel for the respondent has submitted that
It
the
has been filed on
respondent
14th.
has already filed the objection, written objection on 14/11/2023, and same may be called for next case. If prayer is allowed, let this matter be listed again after 1 week after bringing the objection filed by the respondent on record. Let the objection be
Okay.
Item number 17.
Lordship, this matter was sent to mediation. So sincere effort was given from both the side, but
solved.
it could not be sorted out. There is a mediation report, like why is the mediator report?
How much time will you take? It is otherwise now it has to go for hearing.
Lordship, the thing is that the petitioner number 1 by the time has expired. Lordship. We have to take step for removing his name, and we have to file certain documents bringing on record. Lordship. So we seek some time to take the step. Lordship. Maybe after a week.
My lord, the thing is that, my lord, they have filed this quashing petition, my lord, at the stage when in the trial court, the case is pending at the stage of pronouncing the judgment.
It is state.
It is state, my lord.
Okay.
It is state. My lord, the judgment is awaiting since April 2023.
Now we filed a case prior to that, Lordship, but due to the continuous illness of the petitioner number 1, the proper step could not be taken in the High Court for pursuing the matter. We filed it in the month of July 2020.
This is a case under
Section DV
Domestic violence.
domestic violence.
May I hand over the entire order sheet before the trial court, my lord. I have a certified copy of the entire order sheet.
No, whether we have to first decide whether to proceed today or whether should we give time to the petition. Now what you propose
Lordship, the petition number 1 expired.
expired. His name is to be strike out.
And we want to bring on record certain
His
additional.
name may be struck out by your oral observation. I will
Yes,
pass
sir.
an order
Yes, sir. He expired in the meantime.
because no substitution is necessary.
Yes, sir. Because the
Other members,
they are the sole legal heirs. And allegation are against these three only. For the
now what do you want to bring on record?
No, Lordship, we are filing this petition on two grounds. Lordship. We filed the petition number 3 of the husband of the respondent. He filed a restitution petition, and as a counter to that restitution proceeding, Lordship, they have initiated this instant proceeding. So we want to bring the entire proceeding of the restitution proceeding before this honorable court, and also our other grounds are that the
You
respondents
want to file some additional document,
additional law.
but by this, are you not extending the,
No, Lordship, I am seeking a short.
because you are enjoying the benefit of a stay order?
No, Lordship, I'm not on that, Lordship. I'm just pressing for a short adjournment, maybe a week, by fixing it.
Okay, heard Mr. T. Das, learned counsel for the petitioner. Also heard Mr. T. R. Sharma, learned counsel for the respondent. Learned counsel for the petitioner has submitted that during the pendency of this criminal petition, the petitioner number 1, Dinobandhu Pathak, has
Yes.
already expired
On 17/6/20.
on 17/6/2023, and therefore prays for striking out the name of respondent of petitioner number 1. The prayer is allowed. The registry shall strike out the name of petitioner number 1 from the instant criminal petition. Learned counsel for the petitioner has also submitted that he may be allowed at least 1 week time to bring on record certain documents which are necessary for proper adjudication of the instant criminal petition. The prayer is allowed. The petitioner may file an additional affidavit bringing on record the documents which he desires to place before this court within a week from today. Let this case be listed after a week.
May I pray for a date?
Fixed date, after 15 days. After, let this case be fixed again on 8th of December.
Item number 8.
Lordship, the interim order may.
The interim order shall continue till next day.
May I please look for application launcher for passing of complaint under section 500 IPC. Whatever in this case, the mother-in-law, the petitioner is the daughter-in-law. She filed one FIR against the mother-in-law, father-in-law, and husband. The husband was charged and the in-laws were not charged. So thereafter, the mother-in-law has filed a defamation case against me as because they have been defeated. That is the allegation. So the other party, they have appeared today. So truly admitted and fix the matter for hearing.
Okay. Otherwise, this case may.
My lord, before filing this petition, they have filed another revision petition before the learned session judge Hodai.
That is
And the said petition was decided on merit of. And the said fact is
That we have
placed in
stated.
this present
But
petition.
that
No,
is
whether
now we have
we-
come on a question. That was against the order of taking cognizance before the
That or
session judge. That was rejected. That is
Okay,
all right.
no, my query is, can we hear it today or we should fix the date?
as your lordship please.
Case is ready.
That we have stated in our petition. But that is different. Against taking of cognizance, they went before the session court.
Some-
That was rejected. And this is for it to quashing of the whole proceeding.
Well,
Not only taking
some
cognizance.
sort of expression is given in this petition that the said petition was disposed of on withdrawal. Lord.
We have filed a petition that record may be called for. We have filed one application stating that we want to withdraw. But court has passed the
Okay,
order.
okay.
Okay, I
That
have-
part
Heard
is there.
Mr. D. Talukdar, learned counsel for the petitioner. Also heard Mr. M.
M.
Zaman, learned counsel for the respondent number
Two.
2. As well as, who is appearing for, as well as Mr. P. Sharma, learned counsel for respondent number 1. Learned additional public prosecutor representing the respondent number 1. Learned counsel for the parties have submitted that this case is ready for hearing and it may be listed for hearing on the next day. When it may be,
In the month of January.
after 4 weeks, after 4 weeks. The- Accordingly, let this matter be listed for hearing after 4.
Interim order.
The interim order shall continue.
Supplementary list for admission, item number 52.
Video conference. You are for the,
Respondent number 2. The
who has prayed for video conferencing? The
counsel for the petitioner,
petitioner.
but his name in the cause list get reflected on the side of the respondent, Mr. C. Singla.
My lords, I'm appearing for the petitioner. My lords, I'm not well. I'm praying for a short adjournment. Hello? Am I audible, my lords?
Yes. Yes.
My lords, I'm audible.
Yes.
My lords, I'm praying for a short adjournment. I'm not well. I'm counsel based out of Delhi. I like to argue this matter physically before this court. I'm praying for a short adjournment of a week.
He's not well.
But otherwise, I cannot concede to the prayer, but what
My lord, the next date before the trial court is in December. So
Okay.
on the last
Heard Mr. Chirag Singla, learned counsel for the petitioner. Also heard Mr. D. Chakravarti, learned counsel for respondent number 2. Learned counsel for the petitioner, who is appearing in this case through video conferencing, has prayed for an adjournment on the ground that he is not well. Considering the submissions made by learned counsel for the petitioner, learned counsel for the respondent has not opposed the said prayer. Accordingly, the prayer is allowed. Let this matter be listed again on after.
I would pray for a fixed date since they are enjoying a
My
stay.
lord,
So
I
can it
agree to that. No problem.
5th December is okay for.
Yes, my lords. Yes, my lords.
Let this case be listed again on 5th of December. The interim order shall continue till next day.
Oblige, my lords. Oblige.
Bail hearing BA, item number 19 and 20.
This is a lordship. Can it be taken up at 2, my lord?
We have many other matters, so it will be not at 2 exactly. After 2.
Yes, actually, there's a matter going on division bench.
Okay.
May I believe? 439.
Here, my lord, charge sheet laid, my lord.
The sheet has been laid. You appear before the trial court. Heard Mr. S. I. Akant, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet by bearing charge sheet number
199/23 dated 7/11/23.
In view of laying of the charge sheet, this bail application is hereby disposed of with an observation that the petitioner may approach before learned trial court and may pray for regular bail before that court, if so advised.
Item number 22.
May I please your lordship?
Diary not received.
My lord, in this case, as per information, the charge sheet has been submitted already.
Maybe. You appear before the trial court.
Will we appear to the trial court? Already 86 days in custody as of today.
Heard Mr. AK. Heard Mr. AK that learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor. Though learned additional public prosecutor submits that the diary which was called for has not arrived However, learned counsel for the petitioner has submitted that in the meanwhile, the charge sheet has already been laid in this case. And this, and the petitioner may be allowed to approach before the trial court for seeking regular bail before that court. Stop. In view of submissions made by learned counsel for the petitioner, this bail application is disposed of with an observation that the petitioner may approach before learned trial court and may pray for regular bail before that court, if so advised.
Supplement today's item.
Lordship, this is 439 application. Petitioner was arrested on 29/9/2023. Lordship, Lordship may peruse page number 15, Your Lordship. In
Diary not received, my lord.
Lordship, I have a small submission, Lordship. Lordship may kindly peruse page number 15, Lordship. The alleged victim girl was in a relationship with Mr. Ramkumar Chauhan. In this context, she eloped with Mr. Rajkumar Chauhan, and her father lodged an FIR against the Rajkumar Chauhan Lordship. And Rajkumar Chauhan was arrested by the officer in charge, Lanka police station. He was forwarded to jail by the OC Lanka police station, Lordship. Thereafter, he was released on bail on 10/8/2023, page number 21, Lordship, by the district judge Huzai, Lordship.
Okay.
Thereafter, when he was released, he again came with contact with the alleged victim girl, Lordship, and she eloped with Rajkumar Chauhan. Again, Lordship.
Okay.
Thereafter, another FIR is lost, is page number 27, Your Lordship. In this FIR, my name was recorded, Your Lordship. May I read, Your Lordship?
No, but now regarding your involvement.
Yes, Lordship, my involvement was that I'm a friend with Mr. Rajkumar Chauhan. He asked me to drop me in the place where the victim girl was living. So I don't know whether he was contact with this victim girl or not, Lordship. So I dropped him in this place. Therefore, I left this place, and I have no idea whether she allowed to or not. I am in this contact, Lordship, and I am behind the bar more than 48 days, Lordship.
48 days is a long.
Yes, sir. Court below rejected his petition. Bill.
Where is
Page number
29.
29, Lordship. When he was for the first time.
No, we have to verify your submission. Otherwise, what you are submitting, you may be entitled to get.
Lordship, my length of detention may be considered, Lordship. Lordship, may kindly peruse the FIR is page number 27, Your Lordship.
90 days offense, my lord.
From which police station case that you have?
Kaki.
Kaki police station.
Huzai.
When can you produce that?
Protested, my lord.
We are giving it short time.
29.
Lordship
11.
is
29/11.
on 20, Lordship. Because there is no involvement, Lordship.
That we do not know that his name is there.
No, let it be, because today was the first date.
Yes.
No, Lordship is second date, Lordship.
No. Here. Wait. Here.
Can it be on 20, Lordship? And my bail prayer is rejected when for the first time I was.
No, this case is wrongly listed. The order shows that the case was
on 20.
CD on 2011.
2011.
Yes.
So
Here also we have
has
not.
been wrongly listed.
Yeah.
Lordship, it can be on 20, Lordship.
Yes, because on
We
2011,
called that diary on 20.
heard Mr.
S.A. Borbe.
S.A. Borbe, learned counsel for the petitioner, also heard Mr. P.B. Gogoi, learned additional for the prosecution. It appears from record that this case has been wrongly listed today as by order dated 10/11/2023. This case was directed to be listed on 20/11/2023. 11/2023 for case that. Hence, this matter again on 20/11/23 for case that.
Deeply obliged, Lordship.
Hearing 24.
This is circuit committed matter here.
But the petitioner was granted interim bail on 1/3/2022.
Have you cooperated?
Yes, ma'am.
You appeared before I
Yes, madam. We have
heard Mr.
P.H. Kurman.
What is your name?
P.H. Kurman.
P.H. Kumar, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid by the investigating officer bearing charge sheet number
Charge sheet number 103/23 dated 31/3/23. A long.
Stop. Learned counsel for the petitioner has submitted that by order dated 1/3/23, the petitioner was granted interim charge sheet dated is
31/3/23.
okay. The petitioner was allowed to go on interim anticipatory bail, and in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. So, considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to him by order dated 1/3/2023 is hereby made absolute, with condition number 1 and 3 attached to the state order remaining intact. With above observation, this anticipatory bail application is hereby disposed of.
Deeply obliged.
Item number 25.
May it please, Lord. On the 438 application, my lord. FI registered under 306, my lord. Petitioners are on interim, my lord. They appeared before the IO and they have cooperated in investigation.
Okay.
Yes.
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 27/4/23, the petitioners, namely
There are two orders, my lord. First order for petitioner number 1, 3.
petitioner named Ranjit Kumar Roy and Paramesh Adhikari were allowed to go on interim anticipatory bail, and thereafter by order
My
dated
lord, and there is another order 21/3/23. By that order, my lord, petitioner
and
number 3.
prior to that by order dated 21/3/2023, the petitioner number 3, Paramesh Adhikari, was allowed to go on interim bail by this court. And in pursuant to the said orders, all the petitioners have appeared before the investigating officer and have cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Amarhat PS case number 2/2023 and has submitted that all the above named petitioners have appeared before the investigating officer and their statement under section 161 CRPC have also been recorded. Stop. In view of the fact that the above named petitioners have complied with the orders of this court and have cooperated in the investigation, the interim anticipatory bail granted to above named petitioners by order dated 21/3/23 and 27/4/23 respectively is hereby made absolute, with condition number with condition number 2, 3, and 4 in respect of petitioner number 1 and 2 remaining attached to this, their interim anticipatory bail order remaining intact, and condition number 1 attached to the interim bail order dated 21/3/2023 in case of petitioner number 3 remaining intact. With above observation, the instant bail, anticipatory bail application hereby disposed.
Highly obliged, ma'am.
Taking what?
26 and 27.
May I please, Your Lordship? This case, Lordship, we are in interim and we are 26. I am for 26.
Actually, in 27, they mentioned, but
Yes.
27 is also there. Council is there.
Yes, that is it. So Lordship may take up my case, Lordship, at 26. The problem is not there, but
Same case that.
same case that
Who is for 27?
27. Still you
Council is there.
council is there. And we have fully co-part with the investigation from the month of April.
From the month. 27 is also on interim.
Yes, in that case, interim is there.
27 is also on interim.
Madam.
They have cooperated. Then we will dispose it.
Yes, that can be, Lordship, because it is a case of suicide. Affair itself.
In item number 20,
Which was for your
in item number 26, heard Mr. who is appearing? M. Khan, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 10/4/2023, and in pursuant to the direction of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Guwahati GRPS case number 25/23 and has submitted that the petitioner has appeared before the investigating officer, and its statement under section 161 CRPC has also been recorded. Stop. Considering the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 10/4/2023 is hereby made absolute with condition number 2, 3, and 4 attached to the said order remaining intact. In item number 27, heard Miss, what is her name? Mikha Narjani, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Same order. Name of the petitioner will be different, and date of interim bail would be 21/3/23, and instead of the bail condition number 1, attached to the said order will remain intact. Only one. With this observation, the anticipatory bail application is disposed of.
Item 28.
May it please, my lord. My lord, in the last order before the vacation, an updated case diary was called for to ascertain whether I have complied with the orders of the interim bill granted to me. The conditions, my lord, this whole case arises out of a rape case. I was there when people gathered. There's in an FIR at page 16. The lady has lodged an FIR against the accused person, and we caught hold of that accused person that night. And in the morning, we handed him over to the police, and I was an onlooker. I did not assault that alleged rapist. Now, I am on interim bail. The main accused in this case is already granted absolute bail by this Honorable High Court. And I have filed an additional affidavit to.
You have mentioned that you have cooperated.
I have complied with the
in
orders
your
of the
additional
court. My lord,
affidavit.
I have cooperated.
Then case diary Heard Mr. R. Sharma, learned senior counsel assisted by
Yeah.
E. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor, who submits that though the case diary was called for, however, and the updated case diary has not yet been received. On the other hand, learned senior counsel has submitted that the senior counsel for the petitioner has submitted that the petitioner Jakaria alias Jakaria Ahmed was allowed to go on interim anticipatory bail by order dated 5/6/2023, and in person to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation, and to substantiate the submissions made by learned counsel for the learned senior counsel for the petitioner has also submitted that to this effect, the petitioner has also sworn an additional affidavit wherein
Dated 8/9/2020.
additional affidavit on 8/9/2023, wherein it has been stated that the petitioner has complied with the directions of this court and has cooperated in the investigation. In view of the submissions made by learned senior counsel for the petitioner, and also in view of the statements made on affidavit by the petitioner, it appears that the petitioner has cooperated with the in the investigation and has complied with the directions of this court. Therefore, the interim anticipatory bail granted to the petitioner by order dated 5/6/2023 is hereby made absolute with condition number 2 attached to the said order remaining intact. With above observation, this anticipatory bail application is disposed of.
Obliged.
Item number 29.
Heard, Mr.
Yeah.
A. Ahmed, when were you granted bail? In interim bail? 8. Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor, who prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on 8/12 for case diary. The interim order shall continue.
Item number 2.
None appears for the petitioner on call. Learned additional public prosecutor Mr. B. Gogoi prays for another date for producing the case diary. The prayer is allowed. Let this case be listed again on 8/12. The interim order shall continue till next date.
Make the lordship. On this case, my lord, your lordship, the present petitioner is running a crusher machine, my lord, that case. And in fact, his name is my lord Kezuelike, not direct, my lord. Already in time is there, he already appeared, his statement also recorded, my lord. FIR is page 22. That is
You are
regard-
on interim bail.
Yes, already appeared, statement also recorded, my. And directly, my name is not there, my.
His statement is recorded.
Yes.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by you. What's your name? K. Jamal, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. Learned senior counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated 14/9/2023. And in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Govardhana PS case number 129/23 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 161 ARPC has also been recorded. Considering the submissions made by learned senior counsel for the petitioner and considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the present petitioner by order dated 14/9/2023 is hereby made absolute. And this anticipatory bail application is hereby disposed.
Item number 30.
May I please, Your Lordship? 438 application, Your Lordship. In connection with Nalbari PS case number 389/23. The allegation is under section 498A, 313, 506, and 294 and 34 of IPC.
It is there. Yes.
Look, we are we are husband and wife, my lord, and she is living separately from me since about 1 year, my lord. And as and when she doubt me with another girl, FIR name, my lord, one Bandana Deka, she alleged that we have an affair, and as a result of that, my lord, she lost the present FIR. We are already living separately since about 1 year.
When he assaulted? When FIR was lodged?
8/9/23.
FIR was lodged on 8/9.
8/9/20. From the outward,
whether custodial detention would be necessary.
from the material matter.
There are material. How?
That my submission is that, my lord, only because of the affair, my lord, he lost the present affair. And any condition may be given, my lord.
Heard, Mr. This is item number 32. Heard Mr. K. Thakur, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mintu Kumar Das, who is apprehending his arrest in connection with Nalbari PS case number 389/23 under section 498A/506/294/34 of the Indian Penal Code. The gist of accusation in this case is that one Shri Pompi Das, who is the wife of the present petitioner, had lodged an FIR on which date FIR was lodged? On 8/9/2023. No.
Yes.
23, before the officer in charge of Nalbari Sadar Police Station, inter alia, alleging that the petitioner had subjected the first informant to mental and physical cruelty, and as a result of the said cruelty, she suffered miscarriage of her pregnancy. It is also alleged in the affair that the petitioner was having illicit relationship with one another lady, and due to the instigation by the said lady, the petitioner used to torture the first informant. Stop. Learned counsel for the petitioner has submitted that the petitioner and the first informant, though husband and wife in relationship, are living separately from each other since last 1 year. It is also submitted by learned counsel for the petitioner that the first informant suspects that the petitioner is having an illicit relationship with another lady, and due to this suspicion, she has lodged an false FIR against the present petitioner. It is also alleged that it is also submitted that the allegations made against the present petitioner in the FIR are not true. On the other hand, learned additional public prosecutor has produced the case diary of Nalbari PS case number 389/2023 and has submitted that in the meanwhile, the investigating officer has already recorded the statement of victim and few other witnesses, and there are sufficient incriminating material against the present petitioner. Stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary of Nalbari PS case number 389/2023. On perusal of the case diary, it appears that there are sufficient incriminating material against the present petitioner. However, as the dispute between the petitioner and informant is apparently a matrimonial dispute, and as number of witnesses have already been examined by the investigating officer, this court is of considered opinion that custodial detention of the present petitioner may not be necessary. Custodial detention may not be necessary for fair completion of the investigation of the case if the petitioner cooperates with the investigation, cooperates in the investigation. Stop. In view of above, the petitioner, namely Mintu Kumar Das, is hereby directed to appear before the investigating officer of Nalbari PS case number 389/23 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Nalbari PS case number 389/2023, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following condition that he shall not directly or indirectly make any inducement, threat, or promise to the victim / informant or any other person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer or to any court. Number 2, the petitioner shall cooperate in the investigation. With above observation, this anticipatory bail application is hereby disposed of.
Highly observed.
Item number 24.
Yes, Lordship, my tenure is on the kindly pass for time. Well, here we have not received the case there, my lord. Just on the can pass over matter about 2. I prefer short that, my lord. It is not received, my lord. CD not received here. It is long pending matter. But offenses 2 dates also, CD also noted. Offenses are also very serious in nature,
Offense
my lord.
under section
447, 366, 448, 376, 2G.
Okay,
My
case
lord.
diary would be
I do. CD is equal.
heard. Mr.
Yes, okay.
S. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not been received and prays for some more time for producing the same. The prayer is allowed. Let this case be listed again on
My lord. 4th of December, my lord. 4/12. Only around 240, 20. My lord, from Nagaon, my lord, Hanaguri. 1 month was it.
Can it be short?
My lord. Then, my lord, 1st of December.
First.
01. That is a lot. 430, 457 and 57. I have 35. My lord, CD not received, my lord, they are in interim, my lord.
Heard Mr.
Take it.
A.K. Das, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor, who prays for some more
My
time
lord.
for producing the case diary. The prayer is allowed. Let this matter be case be listed on
8th of December. 8th
8th of December.
CD interim.
8th
there
of
is,
December. The interim order
interim.
shall continue till next date.
Here also similar prayer, my lord. We have not received case.
May I please, Lord? The subject matter, Lordship, FIR page 17, Lordship. LC was called from, Lord.
Yes.
Page 7 is the FIR, Lord.
What is the stage of the trial
Appearance, Lordship.
in before the committal court? It
no.
is
JMFC, Lordship. Before the JMFC.
The report is up to my lord 22/8, August 22 only. Thereafter, that
The next date is fixed, my lord, 4/12, my lord, for appearance, Lordship.
how many accused persons are there?
Only one, Lordship. Kindly have a look the FIR, Lordship. Earlier also, the petition approached this court, Lordship, High Court, Honorable High Court, Lordship. Thereafter, that matter was disposed of and directed to file an bail application before the learned session judge. I have filed that application, Lordship, but that was rejected, Lordship. Kindly have a look at the first time, page 17, Lordship.
search frame করেছেন না?
No.
Appearance stage the person.
Why it is in appearance stage? You are already on detained behind.
No, Lordship. I am outside, Lord. I
This is-
absconded, Lordship.
Oh, this is empty.
Absconded, Lordship.
Okay.
Well, I am ready to face the trial. Only some protection may be granted, Lordship. I will appear, Lordship. I will face the trial. The false and fabricated case, Lordship. Due to laugh infection, this lady has been has filed this FIR against me, Lordship. I am only 20 years old,
boy lordship, and she is the married lady lordship. Kindly have a look the affair first. Kindly, man. And earlier lordship, in the Mustal lordship, interim was granted lordship. Kindly some protection may be granted lordship. I am only 20 years old lordship, and she is a married lady. And if your lordship kindly there is the 164 statement lordship. She has admitted that last 20 years she has been making illicit relation with the boy lordship.
This boy,
Yes, lordship.
but you are 20 years old.
Yes, lordship. That is what.
So then how since last 20 years?
It is written in 164 statement lordship. Kindly say lordship. 164 statement of the victim lordship.
Now what is your age?
20 years lordship.
And lady is having illicit relationship with you since last 20
20
years.
years lordship. It is mentioned in the 164 statement lordship. Kindly pay his lordship. I have just read.
Years only. Having it has 20 years.
That may be typographical mistake.
And it is admitted fact that she has the love infection with the boy lordship.
This has to be typographic.
Maybe Lord. That may
Not typographic. Because this handwritten
yes, Lord.
is wrongly recorded.
But does it admitted fact that she had the related with the boy lordship? And in the affair itself also it is written in the same manner lordship.
No NBW against him, my.
No, no,
Huh?
no.
Recall.
No admitted, only someone issued. I have filed my petition lordships, and that was granted lordships. And earlier also I approached this High Court lordship, and I'll see the order lordship, early order, my lord.
Then if summons are issued, why are you apprehending it?
Because it is 376 lordship. If I appear before London Trial Court lordship, I may put bail number because a session tribal case lordship. Magistrate cannot grant bail, my.
Why?
Because 376 industry bail lordship.
Where is the provision that magistrate cannot grant bail?
And this practice is my
No,
running
there
lordship.
is a law.
There is true lordship.
Where is the law? Heard, Mr.
M. Hawk.
Heard, Mr.
M. Hawk.
M. Hawk, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioner Muhammad Babu Ali alias Riazul Haq alias Iazul Haq, who is apprehending that he may be detained in connection with PRC case number 2849/2023 under section 493/376 of the Indian Penal Code. The accusation against the present petitioner is that the victim of this case had lodged an FIR before the officer in charge of Pathori Ghat Police Outpost under Sipajhar Police Station on 8/4/2022, inter alia, alleging that the petitioner, on the pretext of having a love affair with the first informant and on the pretext of marrying her, used to have sexual relationship with the present petition, with the informant. And it is further alleged in the affair that the petitioner used to harass the first informant in absence of her husband. Stop. After lodging of the affair, the investigation, after lodging of the affair, Sipajhar PS case number 147/22 was registered under section 493/376 of the Indian Penal Code, and thereafter, after completion of the investigation, charge sheet was laid against the present petitioner under section. Charge sheet was laid under section
493 oblique
493/376 of the Indian Penal Code, showing the name of the present petitioner in column number 2 of the charge sheet as an absconder. Why you are shown as an absconder?
My lord, police never visited my house.
Learned counsel for the
I have
petitioner
stated
has
my petition lordship.
learned counsel for the petitioner has submitted that during the pendency of the investigation, police never visited the house of the present petitioner, and he was not aware of the pending investigation against him. It is further submitted by learned counsel for the petitioner that though the petitioner has received summons from the court of which court?
Then judicial magistrate first class lordship.
Judicial magistrate first class,
Dorang
learned
Mongolde.
learned judicial magistrate first class, Dorang Mongolde. However, as the offense involved in this case is, one of the offense involved in this case is under section 376, for which what is the maximum punishment? 376.
More than 10 years.
Look, verify. It is imprisonment.
Whoever, except in the cases provided for in the subsection 2, commits theft shall be punished with rigorous imprisonment of either rascal for a term which shall not be less than 10 years,
May extend to?
which may extend to imprisonment for life, and shall also
What
be
was the
liable to
last,
fine.
what was the last claim? Uh, 376 of the Indian Penal Code, and as the maximum punishment prescribed for the said offense is may extend to life imprisonment. Therefore, due to embargo in section 437 within clause 1, 437 within bracket 1 within bracket Roman 2 of the Code of Criminal Procedure, a court of judicial magistrate may not allow the petitioner to go on bail. It is further submitted by learned counsel for the petitioner that if under such circumstances the petitioner appears before the committal court, the committal court would be left with no other option but to reject his bail application and commit him to custody under section 209. . 209 within bracket clause A, small a of the Code of Criminal Procedure. Stop. And therefore he apprehends that even though summons have been issued against the present petitioner, he may be detained behind the bar if he appears before the London Capital Court. The submission on what is your submission?
Cases of serious nature, my lord. So
Learned counsel for the learned. On the other hand, learned additional public prosecutor opposes the grant of bail to the present petitioner on the ground that the offense involved in this case is of serious nature. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor. On perusal of the scanned copy of the case record, which includes the victim's statement under section 164, recorded under section 164 of the Code of Criminal Procedure, it appears that the victim has stated in her statement, stated there that she was having a love affair with the present petitioner. And on the pretext, on the pretext that the petitioner would marry the said victim, they were also having physical relationship with each other. It also appears that though learned committal court has issued summons to the present petitioner, however, the apprehension shown by apprehension as reflected in the submissions made by learned counsel for the petitioner, that as the committal court is a court of judicial magistrate first class, hence due to embargo of section 437 clause 1 clause Roman 1 within bracket Roman 2 and section 309 within bracket 209 within bracket small a 1 small a of the Code of Criminal Procedure, the committal court may not grant bail to the present petitioner even if he appears before the said court in compliance to the summons received by him. In view of above, also considering the submissions made by learned counsel for the petitioner that the petitioner is ready to face trial and shall cooperate in its trial, this court is of considered opinion that detention of the present petitioner may not be necessary if he cooperates in his trial. Therefore, this in view of above, this anticipatory bail application is hereby disposed of with a direct, when is the next date is fixed?
4/12.
With a direction that the petitioner shall appear before the court of learned, which is the court?
Judicial Magistrate First Class,
Court of Learned Judicial Magistrate First Class,
Dorong at Mongolde.
Dorong at Mongolde on 4/12/2023 in compliance to the summons issued to him by the said court. And if he does so on the said date, on his appearance, the learned committal court shall allow the present petitioner to go on bail of rupees 30,000 with one surety of like amount by imposing any condition which the said committal court deems fit to impose. With above observation, this bail application is hereby withdrawn.
My lord, that learned judicial first class is a vacant court right now, lordship. So, flex CGM
Instead of first class, he will appear before the learned Chief Judicial Magistrate.
Lordship.
Darong Matter.
Lordship. Bye, Babu.
Item number 37.
Mayor page lordship. Is a 438 application lordship. FIR page 10 lordship. Due to some misunderstanding between them lordship, both are pen lordship. This was happened lordship. Petitioner is a young boy lordship, 36 years old lordship.
36 years.
36 years.
Young boy.
And lordship, he also is a government chairman lordship. I have annexed page 18 lordship. He is working as a gate 4 employee lordship in the office of the executive engineer PW NS division Golaghat lordship. He will ready to cooperate with the investigation authority lordship. He will appear within 3 days if put his permit lordship.
Where is the FIR?
FIR is page 10 lordship.
What injury has been
My lord,
caused?
injury report is there, my lord. And victim statements are also there, my lord. Assaulted 3 injuries are there, my lord. 1, 2, 3 injuries, my lord. And victim statement is there.
You are saying that he is your friend,
Both are friend lordship.
but he is not saying that you are his friend.
And they known each other lordship. His FIR also named lordship.
Okay. Otherwise, statements of the victim and
My lord.
the witnesses are recorded.
My lord. Although it is, my lord, simple in nature, my lord, but
Sharp
physio-
weapon
my lord,
has been used.
307 is
But
also, my lord.
custodial detention, whether it would be required.
There are no chance of absconding to avoid the trial lordship. He is a
We
government
will
chairman.
impose conditions.
With any condition.
My
lordship.
objection is there, my lord, as it is in the vital part of the, my lord, body, my lord. 307 may come, my
The
lord.
detention will no purpose will serve lordship because he is ready to cooperate with investigation authority.
Vital part means
My lord,
What
neck,
purpose will serve?
neck.
neck, head, that injury.
Already released from hospital lordship. Victim. And being a government chairman lordship, he knows something absconding to avoid the trial. And otherwise his whole family will suffer. He is only bed earner of the family lordship. He is a gate for employee lordship. Already his payment held up by department. Also to notice for his absence. I am ready to cooperate. Within 3 days I will appear with investigation authority to cooperate lordship.
Being a government servant, you also have to be careful not to indulge in.
No, my submission is that no chance of absconding to avoid the trial. That
But what is your submission against the allegations made against?
allegation, it was happened, lordship. I admit it, lordship. But
Due to why it happened?
But
well, due to some misunderstanding between them, lordship.
Mr. This is item number 37.
37.
Heard Mr. U.S. Borgohain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Viraj Kumar Bora, who is apprehending his arrest under section 341/326/307 of the Indian Penal Code. The accusation against the present petitioner in this case is that on 27/9/2023, one Naveen Chandra Bora had lodged an FIR before the officer in charge of Giladhari Police Station, inter alia, alleging that on 26/9/2023 at around 7:30 p.m. when the son of the first informant, namely Parthapratim Bora, was returning back home from the market, and when he reached in front of Puli Kaitoni Gaon LP School, he was assaulted on his hand, chest, and neck by means of sharp weapon. The victim, the name of the accused is not named in the affair.
Accused name in the FIR, Lordship.
My lord, Lordship appears the vernacular, my lord.
Vernacular.
In
The translation is not
not telling with the my
He
lord.
was assaulted by the
My lord,
present petitioner.
my lord. Here Bira Bora, my lord.
Bias Kumar Bora.
He was assaulted by the present petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner is the government servant and you are suspended.
Not suspended, but my payment held up and notice is issued against unauthorized
He is a
absence.
government servant and the victim is a close acquaintance, is well known to the, is a friend of the present petitioner. He is
Similar, my lord. Yes.
friend of the present petitioner, and there was an altercation between both of them due to some misunderstanding. Learned counsel for the petitioner has also submitted that as the petitioner is a government servant, there is no possibility of petitioner fleeing away from the course of justice, and he is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Giladhari PS case number 13/23, which was called for in connection with this case, and has submitted that there are sufficient incriminating material against the present petitioner and has opposed the grant of bail to the present petitioner at this stage. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record, including the case diary of Giladhari PS case number 13/2023, and the injury report as well as statement of the victim recorded under section 161 CRPC. It appears from the injury report that the victim sustained 3 injuries, 3 wounds, and though the weapon which is used in inflicting the injuries to the victim is a sharp weapon, however, the nature of injuries sustained by the victim is found to be of simple nature. It also appears from case diary that in the meanwhile, the petitioner, the investigating officer has recorded the statement of relevant witnesses. Under such circumstances, this court is of considered opinion that if the petitioner cooperates with the investigating officer, his custodial interrogation may not be necessary for fair completion of the investigation in this case. Hence, stop, after stop. Hence, the petitioner Biraj Kumar Bora is hereby directed to appear before the investigating officer of Giladhari PS case number 13/2023 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Giladhari PS case number 13/2023, the above named petitioner shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions: that the petitioner shall not directly or indirectly make any inducement, threat, or promise to the victim or to any other person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts to the investigating officer and to the court. With above observation, this anticipatory bail application is disposed of. Send back the case.
Highly obliged.
Item number 38.
Here, my lord, CD was called for, my lord. We have not received the case there. It is from Sifazar, my lord. Some of them are in.
You are on interim bail.
Some of them is.
Some of
them are.
One in 7, 8, 9, 10. Okay. But here a family dispute, lordship, between the family, lordship.
Let us wait for this. Give a short bit.
My
Heard Mr. A. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not yet been received, and prays for another date for producing the case diary. Stop. The prayer is allowed. Let this case be listed again on
1, my lord, 1/12.
1st of December for case diary.
For orders item number 39.
1/12. Lordship, as for office note dated 14/11/23, the respondent has refused to accept the notice. Perhaps my friend is appearing, my lord.
You are appearing.
Lordship, with regard to item 40, 40, Your Lordship, I have filed my wakalatnama already. This matter is connected with that item number 16, where Mr. Learned Senior Counsel, Mr. B.J. Saikia was appearing, Your Lordship. We had filed our objection with regard to that, and the same was called for.
No, we are taking up item number 39.
39, I'll be filing my wakalatnama.
Okay.
And in 40, I have filed my wakalatnama.
No, wait for 40.
Yes, yes, sir.
My lord, the matter will be take with the item 16, my lord. Transportation 34/23, my lord.
Item number 16, 16.
16, my lord. 2 days late, my lord.
16 order has already been passed.
But that two matters may be take with that.
On
matter
which date it is fixed?
after a week, my lord.
Okay. Third, Mr. S. Islam, learned counsel for the petitioner. Though office note dated 3/11,
14/11.
14/11/2023 shows that the respondent
Refuse to accept.
has refused to accept the notices issued to him by this court. However, Mr.
B. Deuri.
B. Deuri, learned counsel, has appeared in this case and has submitted that he has instructions to appear for the respondent, and he shall be filing his wakalatnama in the course of the day today. The prayer is allowed. Let the name of Mr. B. Deuri be shown in the cause list against this case. Henceforth, stop. Let this case be listed along with
Transfer petition criminal number 30.
along with transfer petition within bracket criminal number
34/2000.
34/2023 within after a period of 1 week.
And 40 is also same, my lord. It
40
also-
same order.
Yes, I have filed already.
Same order. In 40 you have filed.
Here,
Wakalat.
I have filed morning today.
In 40 instead of office note to Nalage, instead of that, Mr. B. Deori has submitted that he has filed Wakalatnama in this case. And the name of Mr. B. Deori be shown as the counsel for the respondent in the cause list.
Okay. Can I pray for a date fixed? Your worship, please.
16 on that, yeah. Let it be after a week, because in 16 we have
Oblige, your lordship.
in the interlocutory application with for the reasons mentioned in the order, the interlocutory application is allowed. The sentence which has been imposed on the applicant/applicant is suspended, and he is allowed to go on bail of ₹50,000. The satisfaction of the sessions judge. Fresh bail has to be paid for satisfaction of the session judge, and during the pendency of the appeal, if he intends to leave the jurisdiction of state of Assam, he has to seek prior leave of the session judge, concerned session judge. And he shall not commit any offense similar to that for which he has been convicted in the case. And the main appeal which is set for hearing in rural courts.
Oblige.
Time being item number 19 and 20.
In this case, Lordship may kindly take up item number 21st. That is criminal petition number 1020/2020.
And copy of the record. Yes. This is for
Quashing
final
of
hearing.
an order.
Quashing of an order.
And that your Lordship may for a moment kindly turn to page 35, your Lordship's order, that will make it clear.
Page 35 of the
Criminal petition.
Yes.
Some observations by your Lordship while I think earlier bail application. The relevant portion your Lordship will find paragraph 8, 7 from 7 Lordship. The learned counsel for the petitioner, page 37.
Yeah.
The learned counsel for the petitioner has laid emphasis on the word as reported used by the learned special judge in the order dated 13/2/2023 to impress upon this court that the charge sheet was not before the learned special judge when the order dated 13/2/2023 was passed.
Otherwise, the learned court would not have used the word as reported in its order. Further, it also appears that as per order of this court, the scanned copy of the register of charge sheet maintained in PI office Karimganj Court for the month of February 2023, along with register of charge sheet of NDPS case maintained by the office of the special judge Karimganj for the month of February 2023 was requisition, and learned counsel for the petitioner submitted that on perusal of PI report, it shows that the PI register does not contain any signature of the magistrate. Similarly, it is also submitted that register of NDPS cases maintained in the office of the learned special judge Karimganj does not contain any sealed signature of the presiding officer. This, according to learned counsel for the petitioner, is in violation of provisions of Rule 38, Part 4 of Assam Police Manual, as well as direction issued by this court. And thereafter, your lordship has made certain observations, and now lordship may kindly turn to para 11, page 38. Page 38, para 11, it says lordship about receipt of scanned copies and perusal by your lordship, and paragraph 12, lordship. On perusal of the scanned copy of the register maintained by the office of the Session Judge Karimganj, it appears that the charge sheet number so dated so in special NDPS case number so was received on 7/2/2023. However, it is also seen that no seal has been put under the signature of the person. So I am here challenging that order 7/2/2023.
Okay.
However, it is also seen that no seal has been put under the signature of the person who has put his signature on the remark column of the said register. Similarly, it is also appears that in the scanned copy of the register maintained in the PI office of the Karimganj Court, that the charge sheet number so was received on 6/2/2023 at 6:15 p.m. at the PI office court. Here, probably your lordship remembers that in the record which was sent, nowhere time was mentioned, but only in respect of this case only, particularly this case, that time was mentioned. However, there appears no signature or seal as required under Rule 38, Part 4 of the Assam Police Manual and as directed by this court in Samsun Noor alias Samsun Noor Supra. The question before this court is as to whether the present petitioner is entitled to get statutory bail. So this part your lordship may skip. Then page 39, third paragraph I am reading, lordship. Though it appears from the registers maintained in the PI court as well as in the court of Session Judge Karimganj, that charge sheet has shown to be laid before the court on 7th February 2023, and it has shown to be submitted before the office of the prosecuting inspector Karimganj Court in the evening of 6 February 2023. Same also appears on perusal of the order dated 7/2/2023 passed by learned Session Judge Karimganj in special NDPS case number so. Though it also appears that the charge sheet and the registers were not signed in the manner prescribed, which raised doubt regarding the date of submission of the charge sheet. However, in view of the judicial order dated so, therefore it was not considered my bail application. Now my case is that there was a specific direction from this honorable court in Samsun Noor case that how charge sheet has to be accepted. On the date of filing of the charge sheet, in the register produced by the PI court, the presiding officer have to put his signature, and the presiding officer have to put his initial in the charge sheet, first page of the charge sheet. In the present case, I have enclosed the charge sheet. Your lordship will find page 29. Page 29, your lordship will not find any initial in the charge sheet. That is, it starts from page 29 to 34.
Yes.
And even in page 34, your lordship will find bottom column, column number 18, lordship. Page 34, column number 18. Dispatched on 22/7/2022. Whereas FIR is dated 14/8/2022.
FIR
14/8/2022. That dispatch date is prior to that, prior to lodging of the FIR. And my now whole submission to your lordship is that as the impugn order that your lordship will find page 41 is passed without considering the directions given by this honorable court.
What was the impugn order?
That page 41, your lordship, sorry, lordship, page page 47. Page 47. Impugn order, page 47, 7/2/2023.
You are challenging this impugn order.
This order.
What would be the consequence if benefit?
If this goes, nothing will prejudice the prosecution, but it will, but if it remains, it will curtail my right to liberty, Lord. No prejudice will cause to the prosecution, sir, if this order goes. But because of this, Lordship, I am behind the path.
How?
Because, Lordship, this order says that charge sheet was submitted on that day.
On
7/2/2020.
Okay.
And because of this order was passed, although your Lordship will find here, case diary of the instant case is received today, let the same be tagged with the instant case record. So on 7/2/2023, already there was a direction to tag the record. But subsequently on 13th, Lordship, there was an observation. Page 26, your Lordship will find that reported word was used. Page 26. If he has seen the Lordship case record, then there is no question of reporting. Page 26, first paragraph, Lordship will see.
No, do you want to say that the 7/2 order was passed later?
It appeared. Because prior to that, your Lordship will find.
How this court will come to that when
that-
this is a judicial order?
Probably, Lordship, that exact finding is not required because the only ground I'm stressing is, Lordship, that the order was not in conformity with Samsung. Therefore, it has to be set aside because Samsung says, Lordship, when the record is put up, then he has to put his initial in the charge sheet. Just I'm taking your Lordship that to the Samsung order, Lordship. Copy already furnished to you, Lordship. That paragraph 43. After discussing all the provisions and laws, Lordship, this direction was given. And direction of this honorable court is binding on the presiding officer.
What direction?
That paragraph 43, your Lordship will find. I'm reading up. Before concluding, Lordship, what?
Yes.
Before concluding, this court further in exercise of powers under section 227 of the Constitution of India would direct that whenever the investigating agency submits the charge sheet to the office of the magistrate, the court competent to take cognizance of the offence, the office of the said magistrate, the court shall on that very day itself place the charge sheet along with forms before the magistrate or at the court, and thereupon the said magistrate, the court, shall put the endorsement with her initials and date along with the seal of the magistrate, the court. So there is no initial on the charge sheet.
Okay. So
So therefore, this order,
Assuming that there is no initial, what would be the consequence?
then the order, the charge sheet, when it was then when lordship cognizance was taken, then that will be taken as the date of filing of charge sheet. Because here in the
No,
Samsun Noor case,
my query is this. Samsun Noor says that, the judgment says that when the charge sheet is laid by the IO before a court, it has to be placed before the magistrate of the same day itself. And to ensure that it was placed, later on no dispute arises regarding the date of filing of the charge sheet, there was a direction that the magistrate will put his signature along with date on the charge sheet when it is placed. Now, in the instant case, no such signatures or dates are, it appears that dates and signatures are not there, not charged. Now, my query is, what would be the consequence of such?
then lordship, that 7/2/2023 cannot be taken as a date of filing of charge sheet. Because this observation was given regarding lordship that for calculating the period of detention, lordship.
So, in this case, when would it be regarded that charge sheet has expired? Which would be the date?
When lordship that initial was put or the cognizance is taken on the basis of the charge sheet.
When the cognizance was taken?
That is subsequently taken, and prior to that, my study period was over.
Okay, okay.
On
the cognizance one was taken by order dated?
Cognizance order, lordship, just order sheet I have enclosed, but I am taking that order.
No, apparently there is a violation of Samsun Noor directive.
Lord.
But that violation is by the PI office.
No, in the charge sheet, lordship, that presiding officer have to put his signature, and that PI code register, that is secondary thing.
So if the signatures are not there, then the accused will get benefit.
Benefit. He will
That
get
is
that.
your main
That is my main.
Then when will we?
On 9th. On 9th.
On 9th. 9th on the sheet is there.
Yes, 9th order sheet is not there. I have filed my application after on 10th lordship, which was taken.
No, in the scan copy, 9th order sheet is not there.
Not there. Yes, scan copy. And even if your lordship kindly for a moment, page 49. Page 49. This is the E-code case history, which is downloaded, and your lordship will not find that 7/2/2023 order. Here all orders are there, even his remand dates are also there, copies are there.
So your submission is short of accusing that this is later inserted order, that you are not emphasizing, but you are saying that this order does not comply with the Samsun Noor because this order should not be taken into consideration for computing the period.
That even if that observation is there, then we'll start my.
Then I have.
And that your lordship has seen that page 49, and in E-code that 7 to.
If that happens, what would be the consequence? Suppose if this order goes, goes for what purpose?
Because it is not it is not in as directed by the lordship Samsun Noor. It is not conformity
Then
with
this
that.
observation that charge sheet is submitted under so and so against the accused person would not be taken into consideration. This observation in the impugn order in line to that charge sheet is, no, my query is when court is saying that charge sheet has been submitted today, why we should not believe it that
Because lordship, there are chances of manipulation, which I am not saying. Supreme Court says, and that observation is there in Samsun Noor also, considering that Supreme Court judgment, that if the initials are not put, if laws are not followed as there is, then there is chance of manipulation. If there is some direction that has to
Where
be
is
followed,
that?
just I am placing that. Just I am reading that paragraph 32, Lordship.
Yes.
A perusal of the said rule 34 clearly mandates that the first information report and the final report forms must be laid as they come in before the district magistrate or the magistrate in charge of the police cases at the headquarters and before the sub-divisional officer at subdivision by such officers as mentioned therein. In case of charge sheet, the same has to be laid before the magistrate by the office who prosecuted or watches the case. It is also seen from the said rule that the officer putting up this form before the magistrate is responsible for obtaining the magistrate's initial or order either on the forms or on the magistrate general diary register as the case may be. This clearly goes to show that it is the magistrate, the court, who has to make an endorsement on the form, and it is the responsibility of the officer who prosecutes or watches the case to obtain the said endorsement by taking the initial of the magistrate.
So
The-
who is that officer?
That PI court officer,
PI,
prosecuting inspector.
prosecuting inspector is under duty to take.
He is also under duty to take signature from the presiding. The form mentioned in Rule 38 is form number 11, which contains the details of the result of police investigation, the date of final report, the date of submission to the magistrate. It is also seen from the said form number 11 that there is a requirement of the magistrate's initiate. Now coming to Rule 69, that manipulation part I am just taking a look at. Yes, paragraph 19, Lord. 19.
Submit.
I will place that paragraph. Okay. It is there. So I have read it. I will place that.
So your submission is if we ignore the impugn order, that is the regarding the fact that charge sheet was laid on that day, then you will be entitled to default pay.
That observation that this charge sheet was not submitted in conformity with the directions given by this honorable court. Therefore, that the said date may not be treated as a date of filing charge. Only that observation will.
Then which date would be treated as date of
Then when the cognizance was taken.
in absence of
Yes. In absence of that initial.
in absence of that initial. Under in such cases, it is always the accused who will get the benefit. That is your submission.
Because the prosecution have to, Lordship, without any doubt, without creating any suspicion, they have to, Lordship.
You point out that manipulation part.
Yes, Lordship, I will.
Means how long you are detained behind the bar?
459 days.
And what was the contraband which has been,
Methamphetamine,
how much?
on the 1,000 suspected Yaba tablets and currency note, and 1,148 grams.
The consequence is if it is set aside that you would automatically get paid.
Lord.
So-
That paragraph 37, that Supreme Court judgment is referred here, Ravindran. Paragraph 30.
Please read.
This aspect of the matter can be looked from another angle. The judgment of the Supreme Court in the case of M. Ravindran Supra and the relevant paragraphs quoted herein above clearly shows that Section 167(2) of the Code is integrally linked with Article 21 of the Constitution of India, and an obligation is cast upon the state under Article 21 of the Constitution of India to follow a fair, just, and reasonable procedure prior to depriving any person of his personal liberty. This valuable right under Section 167(2) of the Code cannot be made nugatory or at the hands of the office of the magistrate oblique the court. It is also relevant herein to take note of the fact that allowing the officer of the magistrate oblique the court to receive on behalf of the magistrate the court may lead to manipulations which would affect the rights of the prosecution as well as accused as the case may be. It is therefore the magistrate, the court competent to take cognizance of the offence, who is required under the law to put the initial with date and the seal of the court on the register maintained in terms with the Assam Police Manual, so that there is no scope of any manipulation. In view of the above testimony,
Then what was the necessity of on the part of the magistrate to pass that order, give that observation? The impugn order.
that probably I cannot argue at this stage.
Now you can, if
Because I have some limitation on that. So this order is on record. I can only place the fact before your lord. And even if your lordship kindly see that from page 41 for a moment, lordship may kindly turn. Page 41, your lordship will find here two orders are there. 1/9/2022, 16/9/2022. Then your lordship will find 29/9/2022, again 13/10/22. Now 26/10/22, page 43, then 9/2/22, two orders. Again in page 44, your lordship will find two orders are there. Page 45, two orders are there. Page 46, two orders are there. Now suddenly in page 47, your lordship will find single order because this is after 14/2/2023. That your lordship will find page 48. Because on 13/2/2023, my default bail was rejected.
So your submission, that submission is that this order was later on.
Create doubt.
Okay. Yes, Mr. Anything else? Their main submission is that here there is non-compliance of the direction of this court in Samsul note.
Not discuss anything or those matters.
Okay, I am reserving this one.
And if your lordship observe that part that this date will not be treated as a date of filing charge sheet, then my bail application is there. Done bail application. Otherwise, I have no submission to made in bail application. Also.
If it is,
If it is allowed, then my bail application is there. And if it is rejected, then otherwise I have no
you are not
submission in
pressing for bail, if
bail.
it is rejected.
That also.
And one more query, that whether you prayed for default bail when it was
Yes,
due.
yes. On immediately I filed. Therefore, lordship, that single order which I have placed before your lordship, on 13th my bail application was rejected default bail prayer. On 13th, by saying that as reported. Therefore, that single order subsequently came out. That was I was placing.
So what to do with the bail application?
Bail application also lordship resolve of this criminal
Okay.
petition.
It may be either allowed or
Sorry,
dismissed.
that, yes. Submission will be same.
Third, Mr. A. Ahmed done in criminal petition part 0. That is item number 20. Item number 20. Third, Mr. A. Ahmed done at counsel for petition. Also heard Mr. B. Cooper done in B. Cooper done at petitioner Cooper. Hearing concluded, order without. Same order in item number 19.
Abdul.
Item number
Itu duta Gitanjali Chepadu.
May I please, Your
Item number 41.
41.
Yes.
So the notice was issued to the respondent number 2, lordship. I have verified, I have checked the lordship office note dated 10/11/23, lordship.
This is a case under
Lordship, 447.
conviction is under
447, 447/34, lordship. He was on bail, lordship. Last occasion, lordship was granted bail to the
no for what it has come up today.
today for lordship for service of this lordship in order of lordship.
No. So the notice
Awaited, lordship.
we have to await.
But
Third, Mr.
IU Chaudhary.
M.U. Chaudhary.
IU Chaudhary.
I.U. Chaudhary, learned counsel for the appellant. Also heard Mr. B. Sharma, learned petitioner prosecutor. From office note dated 10/11/23, it appears that neither the unserved notices nor the AD card against of the notices issued to respondent. Respondent number
2, lordship.
2 has returned.
In amount of
Have yet returned. Therefore, await service. Let this matter be listed again.
lordship, another prayer, lordship. LCR may be called for. Because lordship, in earlier order, lordship, there is no mention.
Let this matter, yes, let this matter be listed again after 40.
Lordship, LCR may be
Let
called
the LCR, let the case record of sessions within bracket T2 case number 214/2017 be called for from the learned trial court.
Obliged. May I please, Your Lordship. I'm sorry I was on late, but I was short.
Here, my lord, it's a 438 bail application. My lord. And my lord, case has already been considered. Considered. The lawsuit will kindly come to page, my lord, 15 is the FIR.
Now,
It is
at what stage the case
that is for appearance. My lord, someone has been issued.
you appear there?
My lord, in fact, my lord, I have already been arrested once, my lord. Your lawsuit will kindly come to my search sheet, my lord. I have annexed, my lord.
Arrested after filing of the charge sheet?
My lord, yes.
After
No,
filing
no,
of,
my lord, before that, man.
then
Before filing of charge sheet, my
thereafter you were granted bail.
lord. I was granted bail. Then, my lord, someone has been issued, my lord, from the court
Okay.
for
Then-
our appearance.
Then why are you before this court?
So before, my lord, this court, because 366 is does, man.
But you were already granted bail earlier.
Yes.
By which court?
By my lord, my lord, there is no order HS because that will be in the city probably because they on the very same day I was released, my lord, by the my lord, police authority.
Without any bail order?
Yes, my lord. Like, in fact, there is bail order as it, my lord, reflects from this my lord, seat, my lord,
366.
366.
What is the maximum punishment?
That is, my lord, 10 years. My lord.
Then the trial court may grant the even committal court can grant you bail. There is no bar.
Yes.
Then you will not get relief under 438.
In fact, my lord,
Then why are you apprehending that you will be
apprehended because of, my lord, that embargo, my lord, under section 20, my lord, 9. My lord.
No, that embargo is not there. In 209 will be applicable if section 437 clause 2 is applicable.
Yes,
And in which cases 437 clause 2 is applicable?
Yes, my lord. 437 subsection 1 clause 2, my lord, and 209A.
So 437, whether 437 subsection 1 clause 2 is applicable in this case?
By the 366, my lord, it prescribes the punishment, my lord.
No such person.
This is imprisonment for 10 years and fine.
No, 437 clause 1 subclause 2 will not be applicable.
Yes, ma'am. That imprisonment for life or imprisonment for 7 years.
No, that is if you are previously convicted.
Yes.
But embargo, you are not previously convicted.
Yes.
Then why 437 clause 1 clause 2 would be applicable?
And
Nine,
that is,
nine.
my lord, 209A also, my lord. Since it's triable by the court.
Now, merely triable by sessions court would not give you that benefit. Aji, today, Abhishek, earlier a similar order was passed. Who took that dictation? I have given what voted a wrong. 437 clause 1.
Yes.
Subclause Roman 1 puts an embargo.
Yes.
Like embargo on the magistrate's court to grant bail for offences where the punishment is with death or with life imprisonment. So only that is the embargo. If for that the magistrate court reject your bail prayer, then 209 clause A would come. If you are not on bail, then at the time of if the case is session case, you will be committed.
Yes.
But where the punishment is not life imprisonment, even magistrate court can grant bail.
Yes.
So you approach before magistrate court. And magistrate court has issued summons to you.
Yes. So I have that apprehension that because this is non-bailable offense and triable by the system. So I have the apprehension that I may be put behind. In fact, I was already granted bail by police authority. Your lordship will kindly come to this page 23 of my charge sheet. Page 23. That is clause 16, my lord. That is date of arrest. Page 23. 4/11/2021. Date of release on bail on the same date, my lord. 4/11/2021. This is also reflected. That is at page 26 also. That the note of the investigating authority. That during investigation, a prima facie case found well established under section so and so.
Now the summons have been issued.
Someone has been issued.
Then the magistrate court would grant you bail. I am disposing of this bail prayer with that authority.
Yes.
Because your apprehension is not.
My apprehension is there. But
Basis is not there.
yes, but I have already been granted bail by the police authority. So once I am granted bail, my lord, there is no any custodial interrogation required.
Mr. Yes, Mr. Sharma. We are disposing of this application. He will approach before the trial court, pray before there, and I will observe that there is no embargo in granting bail. Trial court will consider your prayer for bail on your appearing.
Yes.
Heard Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Muhammad Musarraf Ali, who is apprehending his arrest in connection with what is the PRC case number?
PRC is, my lord, 913/2022, page 27.
913/2022, corresponding to Lahori Ghat PS case number 655/2021 under section 366 of the Indian Penal Code, pending before the Court of Learned Subdivisional Judicial Magistrate S. Moregaon. Stop. Learned counsel for the petitioner has submitted that on the basis of an FIR which was registered. Where is the FIR?
FIR is at, my lord, page 15, man.
Which was registered, which was filed by one Rabul Islam on 2/10/2021, and investigation was conducted, and after completion of the investigation, charge sheet was laid against the present petitioner. In charge sheet, you are shown as an absconder.
No, man. I was arrested even. I was not shown as a absconder, man. So that is I am submitting, my lord. That is, your lordship will see that I was arrested. Date is my lord mentioned in the search sheet itself, my lord. So once
Yes.
that is at page my lord 23. 23, my lord, clause XB1, my lord. Date of arrest and date of release on bail. In fact, there was no public.
Shown as on bail by in the charge sheet. Now, learned counsel for the petitioner has further submitted that now the petitioner has received summons from the Court of Learned Subdivisional Judicial Magistrate S. Moregaon, and next date of appearance is fixed on
That is, my lord, next is, my lord, 21/12/2020.
fixed on 21/12/2023. Still summons are issued. No.
Yes, but yes. In fact,
However, learned counsel submits that though he has received summons from learned committal court, he apprehends that on his appearance before the learned committal court, he may not be allowed to go on bail as the offense involved, as the offense against, as the charge sheet has been laid against him under section 366 of the Indian Penal Code, which is an offense which is exclusively triable by the Court of Session. Stop. I have also heard learned petitioner public prosecutor and peruse the materials available in the case record, including the annexures annexed along with the bail application. On perusal of the material available in the case report, it appears that charge sheet was laid against the present petitioner under section 366 of the Indian Penal Code, and it also appears that the committal court has issued only summons to the present petition. The apprehension of apprehension of the petitioner that he may not be allowed to go on bail as the offense involved in this case is exclusively triable by Court of Session does not have any legal basis, as the maximum punishment for the offense under section 366 IPC. What is the maximum?
10 years, man. 10 years and fine.
It's 10 years.
10 years. It is settlement.
Is 10 years. Therefore, the embargo of section 437 clause 1 within bracket 1 within bracket Roman 1 and Roman 2 Roman 1 would not be applicable in the instant case, as the said embargo is applicable only for those offenses where the maximum punishment is either death penalty or imprisonment for life. In the instant case, the committal court is well within its jurisdiction to consider the application for bail of the present petitioner, and if it finds grounds to release the present petitioner on bail, it may do so. For the reasons mentioned above, this anticipatory bail application is disposed of with an observation that the petitioner may appear before the learned committal court on the next date fixed in compliance to the summons received by the petitioner and may pray for bail before learned committal court. And as there is no embargo in considering the said bail application, the learned committal court would consider the said bail application as per law.
Well, that will be difficult because it's very much under the domain of the court that since my lord, I have received someone because of the fact that this is tribal by state.
That I have explained, there is no embargo.
Even there, my lord, because I have already been granted bail by the investigating authority. So there are Supreme Court judgment to that effect. If there is a bail, my lord, granted by the investigating authority, so meaning thereby he is not. In fact, it is your lordship may grant some time. I will just place it.
Instead of seeking time, you approach before that.
Your lordship may fix it just before rising, my lord. I am placing it. So there is judgment, my lord. If I am granted bail by the investigating authority, then on summon or after such is filed, there can be, my lord, 438 bail application may be, my lord, granted.
No, I am not saying that 438 does not lie after
Yes.
filing of that. I am saying that your apprehension does not have any basis.
That is correct. That is correct. But otherwise,
As your apprehension of getting arrested or not getting bail is not genuine, does not have any basis, which I have mentioned in the order. The trial court is competent enough to consider your bail application, and if you can persuade the trial court, it will grant you bail.
that is, my lord,
And if it does not, if it rejects your application, then you have to approach this.
then definitely, my lord, but they will reject one because, my lord,
Why?
because, my lord, it's the very, my lord, the contents of the FIR, my lord, and that fact that I have already been granted bail, my lord, by the investigating authority, that is, my lord, is not going to be considered by the Nate court. So that is,
You show me that
yes, I will
judgment.
show.
I will include that line of.
Yes.
But your petition is disposed of in terms of the order which I have passed.
Yes.
You will not get anticipatory bail in this court. You have to go to the trial court. I will make an observation if you can show any judgment to that. Today. Okay.
Yes, I please. But today the matter fixed for consideration of bail or suspension of sentence for consideration of bail. Last occasion, lordship was directed to Garnet PT to file their objection. I have verified the office note dated lordship 14/11. They have not filed their objection.
No, will you be filing objection, Mr. Chairman? What is the how much punishment?
10 years.
10 years.
304D.
They may file an
Lordship.
Heard Mr.
IU
Chaudhary, learned counsel for the appellate. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that some time may be allowed to the state respondent to file formal objection against the prayer for suspension of the sentence suspension of the sentence. This order will be in I. Interlocutory application is separately filed. This order will be in I. In main appeal, again heard Mr. IU Chaudhary, learned counsel for the appellant also heard Mr. B. Sharma, learned petitioner public prosecutor. From the office note dated 10/11/2023, it appears that unserved notices has been received back by the registry with an endorsement on the envelope, insufficient address. Insufficient address.
Lordship.
You have to procure the
They properly repeated them as person number 2 from the FIR itself, Lordship. Their address is in the FIR, Lordship. Their address is same.
in view of the office note dated let the office note dated 10/11/23, the appellant is directed to take fresh steps for service of notices on respondent number 2 through the officer in charge of Rupohiat Police Station. The petitioner shall furnish the copies of notice along with the memo of appeal to the registry, and registry shall send the same to the concerned police station. And after service of the notice on the respondent number 2, the officer in charge of concerned police station would submit a report to this court through the registry within
2 days.
No. Through the registry within a period of 4 weeks. You will take steps, the
Within 2
petitioner
days.
says, the appellant shall take steps within 2 days from the date of this. 3 days from the date of this. Let this matter be listed again after court.
Okay. In the meantime, Lordship,
In interlocutory application, that 4 weeks. Let this case be listed again on 18/12.
Lord.
May I please have- I has been filed for suspension of sentence and therefore releasing the appellant on bail. Convicted 163/70 subsection 2.
376.
370 subsection 2. 7 years conviction, Your Lordship. Okay. As on date, my lord, 203 days in jail, Your Lordship.
No, that is not relevant because how many days you are behind the bar? Because you are behind the bar after conviction. Why you should be granted bail?
My lord. The conviction, judgment and order, Your Lordship. There is some error, Your Lordship. During the course of trial into the case, 6 number of witnesses have been examined, Your Lordship. And so while the impugned judgment and order has been passed, out of 6 number of witnesses, my lord, only one witness, regarding only one witness has been mentioned in the judgment, Your Lordship. And regarding 5 numbers of witnesses, the whole judgment is silent, Your Lordship. And if we go through the evidences, my lord,
This is not case for conviction at all.
Why?
Yes, at all. So for statement of the victim, 164 statement, 161 statement, and the examination as a PW2 are not corroborating. And the evidences of 5 witnesses are also not supporting the prosecution case about it. The whole judgment is silent regarding 5 numbers of witnesses, including the investigating officer.
No, you show me some apparent error in the
My-
judgment.
Yes.
Otherwise, we will examine whether we may examine it during the final hearing.
But I may kindly be considered. And this is suspended. In the judgment, my lord, page 16, your lordship, para 13. The evidences of victim discussed, your lordship.
Page 16.
Page 16, para 13.
Yes.
Victim Momina Khatun was examined as PW2. She in her examination in chief had stated that on the day of occurrence, the accused persons, namely Akhtar, Lokman, and Mangu, visited her house and made her board Maruti car and took her to Haskunda Panjipara in the pretext of giving her in marriage with their brother. He further stated that the accused, instead of giving her in marriage, had sold her in a hotel for the purpose of prostitution. She again stated that when she had refused to engage in prostitution work, the accused actually had beaten her with his belt by confining her in a room. He also stated that after 20 days of forceful compulsion for prostitution, he managed to escape from the window of the hotel and took shelter in the house of one old man who had rescued her from the drain where she fell down while escaping from the window of the hotel. He also stated that while staying in the house of the old man, she befriended with one localite of that area, and with his help, she came back to her native place at Hooghly. During cross-examination, her version was consistent. Defense except suggesting that the victim did not make the aforesaid statement before the police had did nothing. The defense even did not deny the fact that the accused person did not took her to Siliguri by practicing fraud and deception and did not hold her at her hotel in Siliguri for the purpose of prostitution. That apart, defense also failed to deny that the accused Akhtar Ali did not physically assault the victim with his belt by confining her in a room for her refusal to engage in prostitution. Furthermore, defense also failed to bring on record anything to show that the victim, for some reason, had falsely implicated the accused person in this case. So, my lord, only on discussing the statement of the victim, my lord, the appellant has been convicted.
What is the wrong?
My lord, lordship may kindly hear the evidence here, lordship. And nothing has been stated regarding other evidence.
So your submission is that on the basis of testimony of the victim, conviction may not be.
And my lord, testimony of the victim and the 164 statement is not corroborating it.
My lord, PW1 at page 24, your lordship. PW1. Informant is the mother of the victim. Page 24. Your lord. I am the informant. I know the accused. The incident took place about 11 years ago. At about
No,
4
Mr. What is your name? A. Rahman.
Tera.
Mr. Rahman. No, we are not going into detail here.
Okay.
For the purpose of the interlocutory application, on what ground, what are your grounds? That
My lord, accused person here
one ground is that the trial court considered only the evidence of victim
Right.
and ignored the other evidence.
And another one is, my lord, there are 3 accused persons. Against 2 accused persons, the charge sheet was submitted. While passing the interim judgment order, my lord, only convicted the present appellant. And regarding other accused persons, totally silent, your lord. My lord, may I read to only one evidence of crime.
Yes.
Page 33. My lord, Prospered. 33. On Sasancha, I was posted as IC Dawangi.
No, you have to also make submission. Why are you reading? What point you are
My lord,
trying to emphasize?
my lord, during the course of investigation also, my lord, the IO has not properly investigated the matter. The proper, my lord, I am reading.
Yeah.
In FIR, the cause of 20 days delay in lodging FIR is not mentioned. After 20 days, FIR has been lodged. I did not ask the victim details about the Nolvari Bhavi. The victim stated in the 164 statement, my lord, that Nolvari Bhavi has taken her with with saying that he would be married with someone. Nolvari Bhavi, who was the mastermind in kidnapping her by administering her intoxicating fund. I did not collect any evidence regarding confinement of the victim at Siliguri in a private hotel, nor did I make any effort to verify the fact regarding the claim of the victim to the effect that she escaped from the window of the aforesaid hotel and took shelter in the house of one aged lady, whom she found outside the aforesaid hotel. I also did not make any effort to collect the details about the aforesaid aged lady. It is a fact that I did not visit the hotel at Siliguri for the purpose of investigation to verify the truthfulness of the statement made by the victim. It is not a fact that the PW1 stated to me during the course of investigation that the accused Akhtar had offered him one mobile phone and rupees 8,000 in lieu of giving his daughter in marriage to him, or else he will take away her daughter by inducing her. So this is the vital point, my lord. The police never visited the hotel, and so far the statement of the victim, he was rescued and took shelter in the Siliguri at in the house of one lady, aged lady, and she is not examined by.
And is it your also submission that there is no evidence against you? Is
My
it
lord.
one of your submission?
My the lordship may kindly peruse the 164 statement. My lord. I got 164 statement, my lord. I have not annexed, but the report is missing. Okay. 164 statement. The 164 statement, he has stated something else.
So what is your submission? So in 164, you are not named.
Some name or there, but some different statement has been given. I may read, my lord. I have not annexed it, my lord. May I read
It is there in record.
in the record?
Okay.
I have the copy.
Yes. Read. please.
আজিৰ পৰা 5 বছৰমান আগতে এদিন গধূলি 7 মান বজাত মোক নলবাৰীয়া ভাবিয়ে sister in law, my lord. Nolbari Bhabi means sister in law of Nolbari. পান খুৱাই মাৰুতিৰে কোচবিহাৰলৈ লৈ যায়। মাৰুতিত 4জন মানুহ আছিল। পান খোৱাৰ পিছত মই কথা ক'ব পৰা নাছিলো। শিলিগুৰিত এখন হোটেলত ৰাখে। মোক শিলিগুৰিত এখন হোটেলত ৰাখে। মোক নলবাৰীয়া ভাবিয়ে হোটেলৰ মালিকৰ ওচৰত বিক্ৰী কৰি গুচি যায়। মই হোটেলৰ খিৰিকীৰে বাহিৰ ওলাওতে আৰু এজনী বুঢ়ী মানুহ লগ পাওঁ। বুঢ়ী মানুহজনীয়ে মোক ছোৱালী হিচাপে ৰাখিছিল। মোক নলবাৰীয়া ভাবি লোকমান আলী, আখতাৰ আলী আৰু আখতাৰ আলী is the present applicant. নলবাৰীয়া ভাবি লোকমান আলী, আখতাৰ আলী আৰু মংগাই শিলিগুৰিত লৈ গৈছিল। ল'ৰাবোৰে ভাবিয়ে মোক বিয়া দিব বুলি নি বিক্ৰী কৰি দিছিল। So main mastermind is Nolbari Bhabi. So for statement under section of and he is not made accused. While submitting the charge sheet also, in the charge sheet also he is not made accused. Nolbari Bhabi. And there are accused Lokman Ali, one Monga Sheikh and Akhtar Ali. Against only the charge sheet submitted Lokman and Akhtar Ali. This has not investigated properly. And one more thing, my lord. It has serious offenses committed, my lord. Why after 20 days of incident, FIR is closed? That is also created controversy. State may kindly be done at any condition during pendency of this minor period.
Any submission? Okay.
While examining.
Okay, I'll go through. Third, Mr. M. Rahman.
Case 28 में kindly read.
Page 28.
Short evidence.
I'll go through it.
Short evidence on neighbor man. He has stated that when he asked the victim, where at the time only 2 line yellow.
Yes.
The informant Kashmir Bibi is my village. I know the accused. The incident took place about 10-12 years ago. I am VTV secretary of village Putimari Part 2. I was VTV secretary at the relevant time also. I heard that the daughter of informant Momina Bibi was missing from home for about 5-6 years. Later on, Momina returned to village along with her husband. I asked Momina as to where she was. Then she told me that she is married and she stayed in Coachbihar or some other place. Her husband belongs to outside of Assam. I do not know as to how Momina went away. Momina earlier got married to one Faku of Kulkumari village. Earlier she was married with one Faku. That is also mentioned in the affair. And later on, the fact is that she got second marriage in the state of West, and she passed 10 years. After 10 years, he came back.
I heard Mr. Rahman for the applicant also heard Mr. Peach fix this case for delivery of order on day after. On what only I was listed.
Along with criminal litigation. Service completed. Record also received.
Main appeal. Heard Mr. A. Rahman that conflict was also heard H. Rahman. The HCR has been received this case for hearing in due course. Appear. No one appears for the petitioner on call. Let this matter instead of
Made with the in this case, as per office note dated 14/11/2023, neither ready card nor answer notice in respect of the respondent number 2 has yet been received. Moreover, the scanned copy of the case record also not received by the same. In this case, there was no interim. The petitioner is an advocate by profession. File this petition under code 82 for what is the matter.
but can copy required.
Notice was issued long back, 3/10/2023, fixing it on 8/11/2023. They may have received, but the office notice can.
Now what is to be done? What may
have without interim.
no, but you have to first ensure that the respondent, who is the
In
respondent?
fact, Lordship, in this case, I am the charge sheeted Lordship accused along with 3 others. In fact, in this case, I am an advocate by profession. Both the parties, seller and buyer, came to my chamber with a deed writer after preparation of the agreement of sale. That I have checked, and thereafter their lordship take a printout and went to the deceased office and applied for NOC. That NOC was, after obtaining the NOC, the sale deed was
At what stage it is pending investigation?
charge sheet submit.
Charge sheet.
Submit.
So what is the stage of the trial?
Page 26. Page 26 is the order. After charge sheet submission, after submission of charge sheet, lordship, notice was issued to the petitioner, but in fact he has not received any notice. But after submission of charge sheet, he filed this instant quashing petition. That is the order by the Honorable High Court that gives bail to the petitioner.
Now what is to be done? Will you take fresh steps or should we await?
Await service report and to reminder for the scan copy giving a short date.
Third Miss R. Chaudhary, Learned Counsel for the Dr. Beecher, Learned Additional Public Prosecutor. From the office note dated 14/11/2023, it appears that neither the AD card nor the unserved notice with respect of notices issued to respondent number 2 has yet been received. Stop. Therefore, await service report. It also appears that the scanned copy of the case record of ER case number 579/2020, as well as scanned copy of the case diary of Karimganj PS case number 185/2020. It was called for connection with this case has also not been received. Issue reminder for the said scan copy. Registered next 6 December
8.
Fixing.
8.
Let this matter be listed again on 8th of
December.
My lord, there is a judgment, my lord. What it is, my lord, settled that my lord, if investigated, my lord, requests no custodial interrogation, and he was not produced during the course of investigation, he is entitled to my lord, be granted.
You show this judgment to the trial court.
In fact, my lord, your lordship consider this aspect of the matter because my lord similarly practiced with me, my, because I was granted bail, my lord, the very same day, my lord, by the investigating authority, my lord. And at the very same fact, my lord, Supreme Court has granted bail. Because in that case also, first, my lord,
No, that is not the question before us. Question before us is trial court, committal court has issued summons to you. You are apprehending that you will not be granted bail if you appear before the committal court in compliance to the summons. My query was, what was the basis of your apprehension?
that is because of
There is no basis because the committal court, because the offense involved in this case is under section 366, for which maximum punishment is 10 years only, though it is a sessions tribal case. These things I have been observed in my order.
In fact, my lord, even then, my lord, trial goes it practice, they retain. Well, my lord, there is a case of this tribal one. They normally, my lord,
I will make that observation so that they are not reluctant to consider. But it is for the trial court to consider when they are competent. you cannot presume that they will reject your bail without making a bail application.
In fact, this is the fact, my lord, what has happened in this case. So earlier, my lord, the appellant before the apex court, my lord, my lord, filed application under 438 for my lord, granting pre-arrest bail. Then that was granted, my lord, on the basis that because since he has already, my lord, cooperated with the investigation, that is the reason he was granted interim pre-arrest bail, my lord, to appear before the court for my lord, and to my lord approach the court, my lord, for regular bail. In that event, my lord, he came to learn that, my lord, there is a notice, my lord, by the court below, by the trial court, that since it's the economic offense, my lord, there should be, my lord, non-bailable warrants should be, my lord, issued. So, having learned that aspect of the matter, my lord, he again, my lord, approached the Supreme Court. As Supreme Court has observed, your lordship will kindly come to para 10 for a moment, my lord. Para 10 of the judgment. So what is exactly, my lord, occurred in this case? Para 10, man. In so far as the present case is concerned, your lordship has got it.
Yes.
And the general principle under section 170 CRPC, the most opposite observation are in subpara 5 of the High Court judgment in the context of an accused in a non-bailable offense whose custody was not required during the period of investigation. In such a scenario, it is appropriate that the accused is released on bail. This is the same case with me, my lord. As the circumstances of his having not been arrested during investigation or not being produced in custody is itself sufficient to entitle him to be released on bail. Next, my lord, the rationale has been succinctly set out that if a person has been enlarged and free for many years and has not even been arrested during investigation, to suddenly direct his arrest and to be incarcerated merely because such has been filed would be contrary to the governing principle of grant of bail. We could not agree more with this. Then last paragraph, my lord, para 13, man. The given factual scenario completely fits the opposite, as the appellant was never taken into custody during investigation. Suffice to say that it would be a fit case for the trial court to grant bail to the appellant on the next date on terms and conditions to its satisfaction. As a measure of precaution, largely arising from the manner of submission of public prosecutor before the trial court, it is made clear that the interim protection granted by this court would continue till the appropriate order is passed by the trial. So in that case, my lord, he was not required for interrogation, my lord, by the investigating authority, or my lord, he was released, my lord, by the investigating authority. So in that view of the matter, there was no requirement of any custodial interrogation. But the court below, my lord, there was an attempt, my lord. So that was the apprehension in that case. Similarly, my lord, although there is no bar, my lord, to entertain my application, even then, my lord, my apprehension is there.
Okay, I'll make required observation.
Yes.
In
And
light
in
of
fact, my lord, I have been arrested and subsequently I was enlarged on bail. That must be, my lord, observed. Para 23 of my suspension.
I'll include the observation of Supreme Court in my order. Okay.
Yeah. In fact, observation might be, my lord, to the effect that I have been already enlarged by the investigating authority. Page 23 of my suspension.
That I will mention in the order. I have already dictated. I will make necessary correction.
For hearing and
May please, the lordship. Lordship, kindly pass over the matter for the time being, as I'm on behalf of S. Prali. He's on another court.
Please. The judgment of conviction matter.
Ready for hearing.
Small matter, matter. Is a conviction under section 489D of the IPC. The sentence to undergo 5 years imprisonment, pay pen of fine of 50,000.
Let's step. This is item number 47.
47. Prosecution case is brief, is my lord, that one of complaint was filed on 24/2/2005, my one Subur Ali, before the officer in charge of Boko police station, alleging that the appellant was apprehended, confined in the office of the Balijan Bazar committee for giving some counterfeit notes, my lord, amounting to ₹100 for purchasing goods in the market. And during the and on the basis of that, fake currency denomination later on, my lord, he was interrogated by police, my lord. On
The
interrogation,
appellant was convicted under 489B.
B, my
For what was the sentence?
sentenced to 5 years, my lord, and a payment of fine of ₹2,000. Now what happened, my lord? So it was a complaint was lodged on 24/2/2005, my lord, by one Subur Ali, before the officer in charge of Boko police station, alleging that appellant was apprehended and confined in the office of Balijan Bazar committee for giving some counterfeit notes for purchasing amounting to ₹100. On the basis of this complaint, my lord, police apprehended him. And during interrogation, my lord, he said similar notes were also in his residence. Accordingly, police went to his residence, seized a number of notes, including around altogether 47 numbers of currency notes were recovered from his possession. And they were sent to forensic laboratory, my lord. The report was given against me, my lord. And accordingly, charge sheet has been submitted on the basis of this report. And during the trial, my charge was framed under section 489B of the Act. Now you are allowed to find the evidence, my lord. There are several witnesses were examined, my lord, including 8 witnesses were examined altogether. The PW1 is the complainant, that is Subur Ali. It says that on year 2005, my lord, I was the secretary of Balija Bazar committee. On the date of I was present in the office of our management committee. At the time hearing commotion in the market, I went and saw the accused caught up by shopkeepers on allegation that he possessed some fake currency. Accordingly, we informed the police. I myself submitted the FIR. Exhibit 1 is my signature. That the police arrived at the spot, seized the some fake currency notes from the accused. Exhibit 2 is the state seizure list. 2 is my signature. The state seized currency notes has been produced in the court. Exhibit M, Exhibit 1 is the lot containing the seized 7 currency notes. So it was 7 currency notes. It is not a fact that the accused got these currency notes by selling metal nuts in the market, and notes which were found in position with sale proceeds collected from the market. It is not a fact the accused has falsely implicated, as there are some disputes regarding payment of Bazar tax. It is not a fact that I falsely deposed in the court. So that is the evidence of PW1. And PW2 is Momin Ali. He is also the president of the Bazar committee. He says that on the date I saw the accused has been caught by the shopkeepers on allegation that he possessed some fake currency notes. Accordingly, we informed the police. Police arrived at the spot. These are fake currency notes. Exhibit 2 is the seizure list. 2 is my signature. Fake currency notes have been produced in the court today. Exhibit a lot of difference. I do not remember anything about the identification marks. It is not a fact that notes which were produced in the court today were not seized from the accused. It is not a fact that the accused got this currency by selling metal nuts. The notes which were found in the position of sale proceeds collected from the market. It is not a fact that the accused has falsely implicated in this case, as there are some disputes in the same person. And number 3, Alpha Zalim. That I was selling shoes in Kapkal on the day. Accused came to my shop, purchased some article by giving ₹100. As the note appeared to be fake one, I returned to him. This ensued the altercation between us. Then the members of the Bazar committee arrived at the spot, took away the accused to the office of the Bazar committee. Later on, the accused was handed over to police. It is not a fact that note given by the accused was not a fake one. It is also not fact I falsely implicated the accused with the LS office. It is not I do not know the note offered by the accused is the lot material exhibit 1 has been allegedly seized by from the position of the accused on that day by police. Then PW4, Niranjan Devnath. Then PW4 was on the date of incident. I was selling sweets at Balija Bazar. The accused came to my shop and purchased 500 grams of sweets by giving 100 rupee notes. Later on, I came to know the accused person purchased articles from by giving some fake fancy notes. I handed over a said note given to him by the accused to the Bazar committee. I remember the same note was given by as this was first 100 rupee note during the transaction in my shop. It's not a fact that there was 700 rupee note in my possession. On that day, I was not sure which note was actually offered by the accused to me. And PW5 is Hakim Ali. He says that on 24/2/2005, I came to Balijar market to purchase some articles. On that day, around 10:30, I saw a huge gathering from the Bazaar coming. Accordingly, I rushed to the place and learned from the people gathered there at the place that some fake currency notes has been detected from the position of the accused who is present in the court today. Police arrived at the boss, seized some 100 currency notes from the position of the accused by the exhibit 2. I am not a member of Bazaar Committee. I did not see the accused selling bottle nuts. The fact that I gave the statement, it's not a fact that I gave the statement before police as per instruction of the president on secretary of the Bazaar Committee. I do not know whether the notes seized from the position of the accused were fake currency notes. But only heard from the public that notes found in the position of the accused were fake. Then comes PW6, Amon Sando Kolita. He happens to be the scientific officer of the Question Document Division of Forensic Sciences. He says that he had received 47 pieces of bank notes of denomination of from the director in connection with Poco Police Case number 39 of 2005. Bank notes of denomination 145 hearing number 36 regional numbers were thoroughly examined. Examination of the aforesaid bank notes were magnifying glass, stereo microscope, QV, IR radiation, transmitted light. He will report both sides of the bank notes marked as Q1 to Q10, Q10 by 1, Q11 to Q41, Q41 by 1 to Q41 are count out. I got the reasons he has given, Your Honor. The papers are already optical active, watermark supported are accepted, and security trade is drawn without any description on it. Integrity printing technology applied, macro prints are applied. The exhibit 3 is the report, and exhibit 3.1 is the signature, which was forwarded by the director A.K. Sinha, and exhibit 4 is the forwarding letter. It is not a fact that fake currency notes are examined by me with such type that any common person will be able to differentiate between notes from the real currency note. Then comes the investigating officer. He says that on 15/6/2000, his name is Gireshwar Putia. On 15/6/2007, I was working as a in-charge Pandya outpost under Poco Police Station. On the day, I received a case diary from Poco Police Station under Section 489 after completion investigation. I collected the FSL report. After completion investigation, I submitted charges against the accused Investors Poro under Section 489 PIPC and sent him to stand up trial. The state section of law. Exhibit 5 is a charge. Exhibit 5.1 is missing. It is the CS also subject for me. Then CWA is Aditya Kumar Das. On 24/2/2005, I was working as in charge of Mandya Police Outpost under Poco Police Station. On that day, about 4:30 p.m., Mostly Poco for BHF informed me that some public has apprehended and confined a person at Kalijar Bazaar. I entered the information in the general diary and proceeded to Kalijar Bazaar along with the staff. The secretary and president of Kalijar Bazaar headed over the accused Investor Poro along with 7 numbers of 4 currency notes of 100 rupees notes, in which I went out making DD entry number 291 dated 24/2/2005. I see the suspected 4 currency notes. Exhibit 2 is the seizure list. 2/4 is my signature. Material exhibit 1 is that these 4 currency notes. I examined and recorded the statement of witnesses. The accused is arrested and taken to Poco Police Station. On Sukur Ali on 25/2/2005, Laws and Ajar with the Poco Police Station. I examined the complainant and recorded the statement. While interrogating the accused, he has admitted he has been possessing some other 4 currency notes in his. I recorded the statement of accused. Exhibit 6 is the disclosure statement. And the accused led us to his house and the presence of the witnesses. The accused produced 40 numbers of 4 currency notes of 100 denomination. I seized the suspected currency notes in presence of witnesses. Exhibit 7 is the seizure list. 7.1 is by signature. And exhibit material exhibit 2 are the 4 currency notes of 100 denomination, which were seized by me and forwarded the accused to the court of law. I drew up the sketch map of the place of occurrence. Exhibit 8 is the sketch map. 8.1 is my signature. I sent the suspected currency to FSL for examination. On the meantime, I got transfer order where I headed over the case diary to the officer in charge of the home. Now, over in the 330 statement, you will see. Then in other examination, my lord, he has stated, my lord. cross-examination. I seized the foreign currency notes in presence of Sukur Ali, Momin Ali, Hakim Ali. He is the secretary of Bolekore. Momin Ali is the president and Hakim Ali is the member of the Bazar committee. Balibazar was situated at a distance of 10 kilometers away from Mondia outpost. I was accompanied by other staff. It is not a fact the investigation of the case was not properly done by me. It is not a fact I seized the sale proceeds of Betel Nut amounting to rupees 1,000 from the accused in Peso Poro. It is not a fact I was biased in investigation of the case in members of the Bazar committee. Now, what has happened in this case, Your Lordship, is accused, my lord, in 330 statement, my lord, he has taken a specific plea, my lord. That plea was that those currency notes, actually he never knew that they were fake currency. And he has received this currency note after selling Betel Nut in the market. That Your Lordship will find the judgment, it has been reflected, my lord. I don't have the 330 statement with me. Your Lordship, kindly see the 330, how many questions were put?
14 questions.
Well, one question.
In 330?
Yes.
14 questions.
14 questions.
14 questions.
Yes. Then here he says, my lord, that he admitted the accused in his statement under 330 that he produced handed over 40 currency notes by him in his house. Then says that
He has taken the stand that he received those notes by selling Betel.
Betel Nut, yes. The accused has sold 20 bags of Betel Nut at a rate of 12.50 per bag. And buyer, while making the payment, gave him those notes. And it was not aware, he was not aware that currency of the bag notes were forged or counterfeit. The accused has not, but the fact remains actually, court also took note of the 330 statement. Where, my lord, he was not properly advised, so he did not adduce any defense in this way.
He will
He did not adduce any defense.
defensive.
Because admittedly, he has in the cross-examination or in his defense, he has admitted that seizure took place in his name. Those notes were found in his possession. His plea is that he was not aware those notes are counterfeit. That's why his case is that doing the transaction because he has sold Betel Nut, he received that money. And he kept the money in his residence and only 700 were taken to Bazar for purchasing some art. And when he was caught by the members of the committee, by the shopkeepers, then only he came to know that these are counterfeit. That is his case, as it appears from the 330. Now, Your Lordship may kindly see the judgment part. That is paragraph 17 in the judgment. Paragraph 17, page 4. Page is 4. The defense plea is revealed from the trains of cross-examination prosecution as well as from the statement of the accused recorded on 161C that the accused sold 20 bags of Betel Nut at the rate of 12.50 per bag, and the buyer, while making the payment, gave him some those notes. Amidst those notes, it was not aware of him that currency or bank notes were forged or counterfeit. Accused has not adduced evidence in support of his defense plea to show that the counterfeit bank notes were given to him by the buyer along with some other genuine notes towards the price of the Betel Nut. Story in receiving the counterfeit bag from a buyer towards the price of Betel Nut engineered by accused is not impressed by me. Accordingly, I have no hesitation to reject the defense plea. The accused had no knowledge at the time of using the bank notes of 100 rupee denomination were counterfeit notes and not genuine one. Factum and ratio of the case referred by the learned defense counsel is not similar to the factum ratio of present case. Accordingly, I am not inclined to accept the submissions put forward by learned defense counsel. Considering the facts and circumstances and summing up the evidence of record of the prosecution, in absence of giving any satisfactory explanation by the accused, it is not known to him that at the time of using the bank notes were counterfeit. I am not considered of the opinion that it can be safely be concluded the accused knowingly, having reason to believe the bank notes to be counterfeit, possessed and used the same for bank notes or 100 denomination as a genuine while purchasing some goods of shopkeepers in Balijar market. Accordingly, I cannot but hold the accused guilty under section 489B of the IPC. That prosecution, that is the finding of the court. Now, in this regard, I like to rely for the picture of Supreme Court. That is 2001 9 SSC page 42. Here also, in this case also, my lord, the session judge sentenced the appellant under section 389B and 389C and sentenced to 3 years rigorous imprisonment on each count in an appeal from the judgment of the High Court, allowing in part the High Court upheld the conviction, reduced the sentence from 3 years to 2 years rigorous imprisonment under 389 and 1 year imprisonment 389C. How the law now for judgment. The gravamen of the charge against the appellant is that on 25/5/2020, about 10, he purchased 1 kilogram of mango costing ₹5. He paid a fake currency of note of ₹100 to PW4, who doubted the genuineness, sold to PW2 and 7, also said that it was a fake currency, and handed over the police to recover 13 more fake currencies, not from him. Similar to me, and further some papers, refills, and different colors of seizures were recovered from his house. On this fact, the charges were framed. After considering the evidence on record, Thane trial judge acquitted him of the charge under 489A, but found him guilty under 22 and sentenced him for the periods noted above. On appeal, High Court confirmed the conviction but reduced the sentence. The conviction of the appellant by trial court was confirmed by the High Court as under 489B and 489C. Now, 489B says, whoever sells or buys or receives from any other person, otherwise traffics or uses as genuine any forged document or forged or counterfeit currency note or bank note, knowing or having reason to believe same to be forged or counterfeit, shall be punished with imprisonment for life or imprisonment as a description of a term, which may extend to 10 years and shall also be liable to fine. And 49C says, whoever has in possession of any forged or counterfeit note, knowing having reason to believe the same to be forged and counterfeit, intending to be used the same in a genuine or that it is may be used as genuine, shall be punished with imprisonment or a term which may extend to 7 years or fine or with both. Section 489 deals with the various economic offences in the respect of forged and counterfeit notes and bank notes. Object of the legislature in enacting this provision is not only to protect the economy of the country, but also provide adequate protection of the currency and bank notes. Currency notes are, in spite of growing customousness to the credit card system, still the backbone of the commercial transaction by the multitudes of the country. These provisions are not meant to punish the unaware possessor or user. That is important. A perusal of the provisions expected above shows that mens rea of the offences 489B and 489, knowing having reason to believe the currency notes in the bank notes are forged or counterfeit. Without the aforementioned mens rea, selling, buying, and receiving from another person, otherwise trafficking or using the genuine or forged counterfeit notes or bank notes is not enough to constitute an offence under 489B IPC. So, possessing even intending to use the forged currency notes in respect of is not sufficient to make out a case under section 489C in absence of mens rea noted above. No materials on brought on record by the prosecution to show that Apple had prerequisite mens rea. High Court, however, completely missed this aspect. The learned trial judge, on the basis of evidence PW2, 4, and 7, able to make out the currency note alleged to have been given by PW fake, they presumed to be such mens rea. On the date of incident, appellant was said to be a 18-year-old student. On the fact of this case, presumption drawn by trial court is not warranted under section 4 of the evidence act. Further, it is not to be shown any specific question with regard to the currency note being fake or not. Put to the appellant in this 313 statement. On this fact, we are no option but to hold the charges against or not proved. We therefore set aside the conviction. So, reason to believe whether I knew that it is false. If I knew it, why should I take the currency note? I would supply to another middleman for selling. That knowledge is not absent.
And it was the burden of the prosecution to show that knowledge was there.
Yes, that is it.
And prosecution, according to you, failed to
prove that
believe that.
he has a mainstay, he has the knowledge or reason to believe that it was. Otherwise, I would not have taken this currency note with, and I would enter into transaction with it.
How will people show that?
The prosecutor, no, they should have examined me. How do I get the note? It is duty of the prosecutor. Who is the battle nut? Actually, whether the battle nut was purchased or not. That part they had to, because it was admitted before the police also. That is difficult to get. It is burden on prosecution to show how I got this 47,000. From where I got, whether I was dealing with it or somebody gave it, or it was mixed with other notes or not. All things are that has not been done.
The burden is not on the accused to show that he.
Right, yes, not on the.
So even if he does not produce any evidence in defense, it is for the prosecution to
prove that I have the knowledge.
Because
The accused has the knowledge. These are our reasons to believe that he had the knowledge that because conduct of the accused, your lordship may have to see. What is his conduct? He has went to the market. He brought some tweets. He brought some articles. They doubted it. He did not doubt. As a possibilities are there. And he also admitted with the police, yes, there are other notes, also similar notes in my position. He took the police. Your lordship may see this conduct also. He produced them everything. He did not pay any hide and seek. So, and the judgment which I have cited, it fits in fact also similar to the judgment which I have fact for the present case. So I pray by your lordship may kindly set aside the judgment of confidence and acquit him of the charge.
Otherwise, you are on bail.
Yes, I am on bail. Okay.
Who is that? Not name. No, other evidence is there that he gave those currency note for purchasing some article, but evidence, whether evidence is there to show that he gave those notes knowing that these are fake. No, on whom the burden lies. No, why are you saying that? Because 106 Evidence Act. Okay, anything else? What is your reply? He says that the prosecution only has to show that it is found in your possession. Then the burden shifts.
No, the
That
burden is whether the law of the country will come. Had there been a case of this, because in some cases, like PCA,
There is no such provision in
Yes,
489B.
89B. There is no such question. Because in these are like 304B, question of 306, the question of 113A, 113B, the question of presumption. In this case, no such presumption can be found. So it is rather it is burden on the
So
prosecution.
it is the burden of the prosecution to show that that is your submission.
Yes.
That as because knowingly possessing counterfeit note is one of the ingredient.
Ingredient of.
That ingredient they have to.
Yes, that I knew it, and knowing it, I have indulged in such. Abusing.
You have to prove only the possession. That is the submission. Okay. Heard Mr. P. Kotoki, and counsel for the appellant. Also heard Mr. P. Gopal, and additional prosecutor. Hearing concluded. Judge to the
Lordship, the matter may be passed for the time being. Council is on leg.
There is no time left for today. It
Actually,
has to be
council is on
adjourned.
leg on court number 13.
We may adjourn it.
They will take here. And there is an interim order, Lord.
This is item number 48. Heard Miss. What is your name?
As taken.
Heard
On
Miss.
behalf of Mr. Arteta.
For the respondent or petitioner?
Petitioner.
Heard Miss S. Soikel, and counsel for the petitioner who submits that the matter may be, who prays for an adjournment on the ground that the conducting counsel, Mr. R. J. Das, is on legs in some other court. Mr. S. Neo P. Borb Gohai, and counsel for the respondent does not oppose the prayer. Hence the prayer is allowed. Let this matter be listed again on December 1st. Let this matter be listed.
5:12.
Let listed again on 5th of December. The interim order shall continue the next day.
49.
May I please? In this case, period, appellant was convicted under section 4 of POSCO Mirror for 7 years and fine of rupees 10,000. And under section 363 IPC for 3 years and fine of rupees 3,000. And he has been in custody.
Under POXO,
Mirror,
how much punishment was imposed?
7.
Okay.
And he has been in custody Mirror for 3 years, 8 months.
We are considering the interlocutory application
No,
or the main appeal.
that was already considered and
It
not
was rejected.
taken.
So you are ready for hearing.
Milord. Thank you.
You will not be concluding it by within 15
Perhaps.
minutes.
Perhaps.
Unlikely.
Yes. It will
What-
take time because yeah.
So what is to be done? We'll fix a fixed short date.
Milord.
When should we fix it?
Milord on 20.
5th of December.
5:12.
Heard Mr.
Yes, sir.
S. Sahu, and counsel for the petitioner, also heard Mr. B. Sharma for the petitioner. This matter could not be heard today due to paucity of time. Hence, let this matter be listed again for hearing on 5th of December.
Item number 15.
My lord, this matter may also take some time, my lord. This is regarding quashing of the criminal proceeding pending before the learned trial court. There is learned CDM 482 petition, my lord.
Now, what do you
Purely as
suggest?
still dispute.
When should we fix it? Heard Mr.
SK Deuri.
S.K. Deuri, learned counsel for the petitioner. Also heard Mr. R.P. Sharma, learned senior counsel, assisted by T. Dole for respondent number 2. State respondent is also there, no?
Yes,
Heard
respondent
Mr. B. Sharma, learned additional public prosecutor, appearing for respondent number 1. Due to paucity of time, this matter could not be heard today. Hence, let this matter be listed on 7th of December for
The interim order.
the interim order shall continue.
Okay.
Item number 1.
The matter may be passed off for it.
Heard Mr. T. Borgohain,
T. Borgohain.
learned counsel for the petitioner, praise for an adjournment.
Kindly fix the matter. Matter may be fixed on 28th of November.
We have to see our
Yes,
12
there is,
December.
but there is higher for bail. Kindly it's on 28th of November.
12 December.
Okay.
Because
First week of December.
on that day also this will happen because we already have cases.
Can it be on 5th December?
Is it possible? Prayer for adjournment is allowed. Let this matter be listed on 5th of December.
Masul.
May I please? Okay, there has to be fixed. Later. Heard Mr.
Yes, Bharali.
S. Bharali, learned counsel for the petition, appellant. Also heard Mr. T. Begum, appearing on behalf of Mr. M. Haloy, learned special PP CBI. Due to paucity of time, this matter could not be taken up for hearing today. Hence, let this matter be listed again on
12
5th.
All right.
इसमें से कोई चीज निकाला है
নাম কেইটা বেলেগ কেইটা একেটাই আজি চিভি দুটা